Good afternoon. Welcome to the August regularly scheduled meeting of the Buncombe County Board of Adjustment. We appreciate those who are here in person as well as those who may be joining us online via the Buncombe County media portals. First, let's turn to staff and see if we have any outstanding announcements.
Good afternoon. This is a reminder about fees. So if you are here, you have paid all of your Board of Adjustment ZPH fees. We've been getting a slew of, or applicants have been getting a slew of emails from falsified accounts trying to get you to pay fees. We will never ask for a wire transfer or a gift card. It will come from our website directly. If anything looks suspicious, please do let us know. You can forward it to the planner assigned your case, or you can forward it to planninginfo@buncombenc.gov, and we'll take a look at it. Thank you.
All right, next, let's do a roll call of participating board members and staff today. Joel?
Joel Mazelis.
Paul Wilczynski.
Wesley Green.
Craig Allen.
Greg Phillips.
Gabe Quisenberry.
Mark Diaz.
Griffin Kearns.
Dana Alley.
Jason Payne.
Savannah Glantz.
Amy Broughton. Tarana Sauter.
Thank you. Staff, do we have any prior meeting minutes to approve? I believe some came in yesterday. Any questions or discussions on our July meeting minutes?
Yeah, move to accept.
I move to accept. All in favor, say aye.
Aye.
Any opposed? Meeting minutes for July approved. All right, now I'm going to go through some administrative items for the public at large and everybody here. We ask that everybody in attendance please silence their devices for the duration of this meeting. If you find yourself needing to take a call or engage in a conversation above a whisper, please take those conversations outside the room so that we don't distract those others who are in attendance. Due to the challenging acoustics of this room and the fact that we may have those online wishing to hear the conversation, we ask that you use the audio equipment. So approach and utilize a microphone. Ensure that the microphone is on. And then keep that microphone within 6 inches of you so that those here in attendance and those online can hear your voice. This meeting is a quasi-judicial evidentiary hearing. A member of any board exercising quasi-judicial functions pursuant to the North Carolina General Statutes shall not participate in or vote on any quasi-judicial matter in a manner that would be, or that would violate, any person's constitutional rights to an impartial decision maker. Impermissible violations of due process include, but are not limited to, a board member having a fixed opinion prior to the hearing that is not susceptible to change, an undisclosed ex parte communication, close familial or business relationships, or other associational relationships with an affected person, or a financial interest in the outcome of the matter. With these expectations we place on board members, we ask members of the public to avoid contacting board members about any specifics of any case, past or upcoming. Board members are expected to consider all of the evidence submitted by the applicant, the staff report, and supporting materials and any admitted evidence during the hearing. This protocol keeps the process fair for the applicants and for members of the public who should expect this process to play out in a public meeting. Board members will now affirm whether they have any impermissible violations of due process or whether they have reason to be considered an impartial decision maker. Joel?
No.
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 In the interest of full disclosure, I see we have ZPH 00027 Georgetown Self Storage. My wife and I currently rent one of those units at that facility, but we have no relationship with the owners, and we have no financial interest in the facility other than just renting a unit.
Has there been any communication, Mark, between you and the owners about this case?
None.
Amy, do you see any issues or concerns? All right, thank you. All right, for those who are members of the public joining us, And if you are here wishing to take part in the hearing today, you have two options. One is as a party withstanding, and the other is as a witness. Anyone may speak as a witness. However, those wishing to be considered a party withstanding, this board will determine one's qualifications and will make the decision on whether the request for standing is approved. Any individual wishing to participate as a party withstanding should have prepared in advance their case to be presented to this board, showing that they are uniquely affected by the proposed project. They should also be prepared to present credible evidence of special damages. Their case should be based on material facts and supported by expert opinion testimony where required. Before this board makes the determination of an individual being a party withstanding, the applicant filing the case with this board will have the opportunity to cross-examine any individual requesting standing. Should this board deem an individual as being a party withstanding, that individual will be an active participant in the case. They may cross-examine the applicant and the applicant's presenters and experts. Parties withstanding and their experts may present testimony. If the board does not approve an individual's request for standing, that individual may choose to address the board as a witness. General witness testimony is limited to facts and not opinions. If you will be speaking as a witness today, please focus on the facts and standards, not personal preference or opinions. The board can hear facts from your personal experience, but cannot consider your opinions on certain topics with the same weight as an individual who is qualified as an expert in that field and provided expert opinion testimony. The opportunity for witness comments will come shortly before the board closes the public part of the case and moves to board deliberations. Although there is somewhat of an informal nature to the proceedings today, interruptions of presentations by parties to the hearing or from the general public will not be tolerated, and members of the public may be asked to vacate the room if this becomes an issue. The board, however, may interject to keep the hearing on topic, to keep the record to the related facts, and to move the proceedings along in fairness to the upcoming cases on today's agenda. As mentioned earlier, this is a hearing of quasi-judicial evidentiary hearing. That means that similar to court hearings, state law sets specific procedures and rules concerning how this board must make its decisions. The board's discretion is limited. We must base our decision upon competent, relevant, and substantial evidence in the record. Our decisions must be constrained by the standards in the zoning ordinance and based on facts presented. For certain topics such as traffic impacts and projections about property values, this board needs to hear opinion testimony from expert witnesses. Individuals providing expert opinion testimony will be qualified as experts by this board and provide the factual evidence upon which they base their expert opinion. Thank you for your patience on the administrative matters. Now let's move to, do we have a revisiting or a request for a change on first case slated ZPH 202500038 Carroll at Sweeten Creek? Any developments on that case?
Good afternoon, board, chair, staff. My name is Derek Allen. I represent the applicant. We've been working with the neighbor property owner, as you guys may recall. We would ask for a continuance for one more month while we finish out the details of our agreement, and we believe that we will be in a position next month to have it heard with no opposition from the neighboring property owner.
And I see that party withstanding is.
We're aligned with that.
You're in agreement with that?
Yes, sir.
Any questions from the board on this matter? Any motions?
Yeah, this isn't a question, it's a comment. I'm getting a little tired of these continuances. If we were going to do a continuance, I would personally like to see it made, we do it next month or not at all. That's my own preference.
So with that concern, Paul prompts a question. What specifically do you expect to achieve between now and the next scheduled meeting?
We have and have submitted now to the county a revised site plan that reconfigures it and also has a land swap that's attached to it. And so it's a little more complicated than just we need more time. We're actually executing real property documents that accomplish a land swap to move a building.
Okay,
But we will be prepared next month to move forward.
all right. Joel, any other questions or concerns? We have a motion to postpone.
Motion to postpone to next month.
Second.
All in favor?
Aye.
Thank you.
Okay. All right. All right, so let's proceed to our next case. That would be ZPH 2026-00027. That's Georgetown Self Storage Phase 3. Member of staff is going to come forth and present that case.
Please raise your right hand and state your name.
Griffin Kearns?
Do you swear or affirm to tell the truth at this hearing?
I do. Is this close enough for you all to hear me? Great. Good afternoon, members of the board. I certify that this public hearing was properly noticed and that all applicable parties were notified of the meeting in accordance with general statutes and county code. I ask that all applicant and staff materials be accepted into the record as evidence.
So noted and so accepted.
I think all of you know who I am, but for those in the room that do not, I'm Griffin Kearns, planner with Buncombe County. I completed the staff review of ZPH 2026-00027, the Georgetown Self Storage Phase 3 Special Use Permit. The applicant is Marty Kokot of Landworks Engineering on behalf of the owner, Jeffrey Brown, trustee of the Jeffrey Thomas Brown Revocable Trust. Subject property is located at 935 New Leicester Highway. This is near the intersection of New Leicester Highway and O'Donnell Road. Size of the subject property is 3.22 acres. No water or wastewater utilities are proposed to service this phase of the development. Property is in the open use zoning district with no overlays. The applicant is requesting a special use permit to expand an existing self-storage facility by constructing 3 new storage buildings. The overall facility consists of 2 parcels, one previously developed with an office building and 12 storage buildings, and a second parcel directly to the north with 4 other pre-existing storage buildings. The special use permit application pertains specifically to the northern parcel only, which is being considered a level 2 planned unit development due to a proposed total of more than 4 principal buildings on this one parcel. As this is in the open use district, no deviations from zoning dimensional requirements would be applicable. The minimum building separation of 20 feet as required in a planned unit development will be satisfied per the plans. Staff recommend, if the special use permit is approved, the following conditions of approval be included in the board's order. Number 1, the project must be constructed as depicted in the site plan. Number 2, prior to commencement of land disturbance and construction activity, the applicant shall submit a site plan development permit for the entire project indicating the following information: exact location of all buildings and accessory structures, commercial lighting plan demonstrating it meets the standards of the zoning ordinance, buffering, landscaping, and parking lot landscaping if required, retaining walls demonstrating they meet the standards of the zone retaining wall ordinance, easements and rights-of-way on the property, approved E911 road names to be approved by the addressing coordinator before submittal, any other conditions of site development approved by the Board of Adjustment, and copies of approved permits from the U.S. Army Corps of Engineers, the North Carolina Department of Transportation, and the North Carolina Department of Environmental Quality where applicable. Number 3, this master site plan permit approval shall not replace the requirement of pulling an individual site plan permit for each building or structure within the development. Number 4, the applicant must agree in writing to these conditions prior to the commencement of site work. Finally, I will note that previous site work on the subject property was commenced in association with prior phases of development, or it was approved by staff under prior permits, including a stormwater permit that was issued in April of this year. While these staff suggested conditions are standard for all special use permits, I do want to make clear that any previous work on this site in compliance with those prior staff approvals before the applicant's agreement to these special use permit conditions should not be considered a violation of the conditions. With that, I am happy to answer any questions you may have. Thank you all.
Do you have anyone here, to your knowledge, that is asking to be a witness or requesting?
We have 2 standing applications.
And by name, do we have them identified?
I'm sorry, no, we don't. I was looking at the wrong case. That's my bad.
The gentleman here in the audience is standing. I assume he is requesting opportunity to address the board. Just go over there.
I'm Marty Cocott, the
Marty
engineer of record for the project. And I just wanted to be here today. Excuse me. Marty Cocott with Landworks Engineering, representing Jeffrey Brown, the owner on the project, who's also present should you need to speak to him. I am the engineer of record on the project and the reason we're here before you today. So
Could I clarify, are you here representing and speaking on behalf of the applicant?
yes, sir.
All right. At this point, clarification, do we need to hear Marty's testimony at this point in time?
Yes.
Yeah.
We need to swear him in.
Go ahead and
as well.
swear Marty in, please.
Can you please raise your right hand and state your name?
Martin Cocott.
Do you swear or affirm to tell the truth at this hearing?
Yes,
Thank you.
you're welcome.
Mr. Chair, can I ask a question?
Go right ahead, Paul.
If we're in the process of evaluating requests for standing, and it doesn't sound to me like this gentleman is applying for standing, why is he testifying now?
Well, I'm going to make sure that Marty understands that this is the stage in the process where generally people come forward who have a challenge or a question of the applicant's project.
Okay.
And so at that point, then we're trying to determine whether the individual, yourself, has a legitimate position that allows them to become a party to the case and to bring forth countering witnesses.
Okay.
Are you supportive of the applicant's case, or?
Mr. Chair,
Yes.
just want to let you know, there were no standing applicants, and this is the applicant. So we actually sort of skipped the standing issue and moved straight to the applicant. I don't think that was clear.
Okay, all right. I didn't hear that either. Yes. So then Marty is the applicant and not an individual requesting parties of standing.
Represents the applicant.
Okay, all right. Sorry for the confusion, Marty.
Not a-
Proceed. Go
not a
right ahead
issue.
and proceed.
Okay. I just, wanted to make sure you understood that the reason we're here to get a special use permit on a project that's been, portions have been constructed for over 24 years now. That is because on this individual parcel, we've exceeded 4 buildings and therefore have to comply with the special use permit. The buildings are very similar in size and scope to what's already built, and I'm happy to answer any questions regarding the site, the arrangement, buildings, erosion control, or stormwater, which we already have permitted.
Thank you, Marty. Any questions of the applicant from the members on the board?
Well, thank you.
Thank you. And again, at this point, or anyone who's coming forth as a witness who would like to testify? Hearing none, then we'll close the public session and move to board deliberations and discussion and a motion. Any issues or concerns that you see in this request, if it's worthy of discussion amongst board members? Hearing none, anyone to volunteer to take the script?
Mr. Chair, based on the evidence presented to this board, including the following exhibits, the petitioner's application, the submitted development plan, the GIS maps, staff report, and testimony presented at the hearing, I move the board adopt the following findings of fact: that this matter was properly advertised, is within the board's jurisdiction, and is ripe for its consideration, and that this application, together with the conditions proposed by staff and/or this board and agreed to by the applicant, if any, does meet the requirements for granting a special use permit contained in Buncombe County Code of Ordinances, Section 78-6213.
We have a motion. Is there a second? All in favor, say aye.
Aye.
Those opposed? Okay, an additional motion?
Okay. Based on the foregoing findings of fact and for reasons set forth therein, I move that the requested special use permit be approved and that the order approving the permit be adopted and executed as presented and as modified in this meeting.
And a motion's been brought forth. Is there a second?
Second.
All in favor? Aye.
Aye.
Any opposed? Motion passes. Amy, are you prepared?
I am. So dispensing with the caption, I have prepared an order. This matter was properly noticed and advertised. Jurisdiction is appropriate. The applicant has applied for a special use permit pursuant to the zoning ordinance for the addition of 3 additional storage buildings on an existing storage facility on New Leicester Highway. The property is located in an open use district. Parties and the applicant, parties withstanding were given the opportunity to offer oral and documentary evidence. There were none. Pursuant to the Buncombe County zoning ordinance, the board finds the following: that this is a planned unit development level 2, and those standards are found in section 78-678B sub 7. The land within the PUD will be under single ownership or management by the applicant before final approval. I believe it already is under single ownership. The density is consistent with the intent of the district in which it is located and conforms to that permitted in the district. The land within the PUD will include only non-residential uses. The proposed heights in the application are less than the maximum allowed in the commercial zoning, the open use district. Is that correct? Is it open? Okay. The proposed parking complies with the spirit and intent of the section applicable. Pursuant to the Buncombe County zoning ordinance, satisfactory provision and arrangements have been made for the following: the proposed use will not adversely affect the health or safety of persons residing or working in the neighborhood. The proposed use will not be detrimental to the public welfare or injurious to property or public improvements. The use will not cause or have adverse effects on surrounding properties due to noise, vibration, odor, or glare. Satisfactory ingress and egress for the proposed use have been provided. Provision for off-street parking and loading where required has been arranged for. Provision of adequate and proper utilities have been arranged for. Provision of buffering, if necessary, has been arranged for. Signs, if any, and proposed exterior lighting are in harmony with properties in the district. Playgrounds, open spaces, yards, landscaping, access ways, and pedestrian ways have been arranged for. Buildings and structures with reference to location, size, and use are acceptable. Hours of operation, with particular reference to protecting and maintaining the character of the neighborhood, are acceptable. The following conditions will be necessary, and those are the standard conditions that the board imposes and were read by Mr. Griffin. So based on the foregoing findings of fact, The board makes the following conclusions of law: that the applicant's request for a special use permit, together with the imposition of the conditions recited and are incorporated herein as if fully set forth, meets each applicable requirement of the Buncombe County zoning ordinance. Now therefore, based on the foregoing findings of fact and conclusions of law, the Buncombe County Board of Adjustment orders that the applicant is hereby granted a special use permit to establish a planned unit development on the property as requested, subject to the conditions referenced above, which are incorporated as if fully set forth herein, August 12th, 2026.
Any questions? We have a motion to accept.
Second.
All in favor, say aye.
Aye.
Any opposed? Nay? It is approved. Congratulations. Thank you, Marty. All right, so let's move on to our next case. That would be ZPH 2026-00025, Cogdill Variance. Oh, are we doing, did I threw a curve at you? I'm sorry. Yeah, let's restart case 0001 on Alden Asheville SUP. Thank you, Jason, for your patience.
Please raise your right hand and state your name.
Jason Payne?
Do you swear or affirm to tell the truth at this hearing?
I do.
Thank you.
Good afternoon, Board. I certify that this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with the general statutes and county code. I ask that all applicant and staff materials be accepted into the record as evidence.
So noted and accepted.
This is the review of ZPH 2026-00018, Alden Asheville Special Use Permit. The applicant is Charlie Sabin of Flournoy Development Group, and the owners are James and Madge Reed. The property is located at 1110 and 1116 Glenbridge Road Southeast. The combined size of the properties is 29.3 acres. This project will be served by MSD Sewer and City of Asheville Water. The properties are zoned EMP for Employment District, and the applicant has applied for a Planned Unit Development 1 to construct 191 townhome-style units across 34 structures, including a clubhouse and amenities. I want to be clear that for this particular project, there is no subdivision component, so while these are arranged in a style and will look like townhomes, they are not townhomes proper, as there is no land to be subdivided there. The parcel will be under one common owner. The deviations being requested for this would be only a separation of the building separation requirement from 20 feet to 0 feet, just to accommodate the shared walls on these townhome-style units. However, it should be noted that the buildings themselves from other structures will meet the 20-foot separation. Staff recommends the following conditions, if this is to be approved: that a recombination of the two pins on this application must take place before and a new pin assigned to the new parent or to the new parcel prior to submitting a site plan application. A NCDOT driveway permit is required, and the project must be constructed as depicted in the site plan. Does anyone have any questions?
Any questions of the board?
Yeah, I have a question. Did we hear this case once before?
No, this is the first time. There have been other special use permits that have come before this board in the immediate area, but not this project, no.
Okay.
Other questions? Thank you, Jason.
Thank you.
There are 4 standing applications for this case.
Okay.
Should we just start from the top? It starts with Durgarabedian. Sorry, I butchered that.
Let's go ahead and proceed and be sworn in.
Please raise your right hand and state your name.
David Eric Durgarabedian.
Do you swear or affirm to tell the truth at this hearing?
Yes.
Thank you.
So was it David or Derek?
David Eric. I go by Eric, but whatever.
So just for the sake of expediency, this point in our deliberations is to determine whether you can speak as a witness or whether you will speak as someone who is a party withstanding.
Okay.
So we're interested in knowing your particular situation
Okay.
about you and how you will be impacted by the applicant.
Okay.
Not interested at this point in time about your opinions of what the applicant is
Right.
proposing to do. So go
Right.
forward.
Okay. So my property borders this Alden Asheville. About 60 feet of my property borders this. I'm in the neighborhood Hadley Park. And I did have some questions. I was in the Zoom call and listened to the engineer go over a lot of stuff, but I just wanted to clarify any of that. Is this the place to do that? Some of these the specs that are on the site plan and stuff like that, I'm worried about setbacks and, I know they have a landscape buffer. I'm not sure of the Buncombe County setback beyond the landscape buffer that they're providing around the property.
Okay.
That is the biggest stuff that, involves me. Because it's all trees right now, and I'm sure those will come down, so.
Yeah. Yeah.
I wanted this on record, because I'm worried about these distances, and I'm worried about how that'll affect, of course, my property, that value.
Is your situation any different than any other property owner that also shares a boundary with the applicant's project?
There is approximately 10 homes that border that and will have this landscape buffer along it. The townhomes don't start till my property and then move, I guess, south along our border with our neighborhood. So, I'm just, townhomes are tall. So you've got this buffer, then you have a setback. I'm just trying to determine, the distance and if the builder's gonna stick to the site plan.
Okay. Counselor representing the applicant.
Good afternoon, Mr. Chairman, members of the board. I'm Craig Justice. Mr. Chairman, usually during this phase, what I say is, I can't concede to someone. However, this process needs to be fully transparent. Although they may not have standing, we want to treat them like we're not barring them from asking questions, getting the information they need to get. Obviously, if they want to be a witness and they want to provide information relevant, they can do that. But although I don't concede to the gentleman's standing, he has asked, is this the appropriate time? It will be the appropriate time. And I think he hopefully will be very pleased with the explanation of setbacks and buffers and all that, because we're going to go through that, and I want to give you every opportunity to ask questions. It's not right this minute, but it will be during these proceedings before we close. So while I can't concede to his standing, and you did ask the appropriate questions, Mr. Chairman, about, are you showing special damages? This is the time for them to produce proof. I will note that on his application form, he checked the box that he didn't have special damages. He mentioned his office as, I think, president of an HOA, but so he even checks that he's not unique. So these are the things I want to say without letting this gentleman know that somehow we're not here to answer his questions, because we are.
All right, David, any questions you have with regards to Mr. Justice's comments?
No, it's just,
No. It's
as
just,
long as these things get clarified,
okay.
you know.
So we have a motion, you want to bring forth a motion regarding the request for standing?
Yeah, before we do that, can I just clarify my understanding as to what Mr. Justice just said, which I definitely appreciated? Is Mr. Justice suggesting that sometime after this, that in the middle of the hearing, that he's going to be allowed to ask questions?
Yes, and I've done this at other proceedings.
Yes.
This is a transparent process.
Yes.
And while I assume there are some attorneys who say you have to be a party with standing, as long as the chairman is fine with the process, when we get through with the witness and there are folks who have signed up who want to ask questions, it's fair game. I want them to be able to ask questions. I think we're going to get all the right answers, but I want them to be able to ask the questions. So that you are correct, that I want at some point in time for this gentleman to be able to ask our folks questions about setbacks and the buffer, so he can feel good going away from this that he had an opportunity.
It could be my memory is failing me, but I don't remember ever seeing this process happen, and I'm not terribly comfortable with it. So could I suggest that the gentleman right now, only speaking in one direction, ask whatever questions he has, and then when your client has their testimony, that they answer those questions, but not...
Paul, before we proceed, Amy, just for clarification's sake.
Sure.
Does the board have the authority to respond to Mr. Justice's proposal to allow for the answering of any witnesses' questions during the proceedings?
You absolutely do. You can structure the hearing, but I did want to say that this gentleman has filed a motion for standing.
Correct.
And I think the board has to make a decision on that, because if the board finds that he does have standing, additional rights come with that finding. So if, if the board were finding out standing, then the applicant would be able to ask questions, participate, and then if the board found that he did not have standing, he could raise those issues as a witness or in response to Mr. Justice's opening the hearing up to other witnesses. But I think the board needs to make a decision with respect to standing. And so far, the information you have is that his property abuts the applicant property by about 60 feet, and you may want to inquire further into whether or not he actually does have special damages. I know that the forms can be a little confusing to people who don't go through this process every day, so that additional inquiry might be appropriate.
Mr. Chair, I would suggest that if he is unable to demonstrate special damages in this particular case, which we haven't heard yet, they be given the opportunity to withdraw his standing application and participate as a witness at the end of the public hearing for this case, like we typically do. Sounds like he's got more questions and that's, kind of our typical process, if that's the case, unless this board, during this conversation right now decides he does have standing, which we haven't closed yet.
So David, Eric, would you be interested in what Councilman Gabe has proposed, that you step back from your request for standing and come forth at the time as a witness if during the proceedings the questions that you have not been answered, and then proceed with posing those questions at that time? And counsel for applicant has stated that they'd be prepared to answer those questions to the best of their ability?
Yeah, yes.
Okay. So we will accept your withdrawal for request for party with standing.
All right. Thank you.
Thank you. Any other applicants or members of the public requesting standing?
Yes, we have Carroll Martin.
Ms. Martin, please come forward.
I also have some handout. I'm not sure how to get that information to you folks so you can see what my special characterization is for my property.
So this is material that is related to your specific
Yes, absolutely.
situation? Okay, all right, please.
Carol,
Do
can
we
I
have a
please
copy?
swear you in?
Okay,
Thank you.
Accept or not accept the evidence with respect only to the issue of standing at this
correct.
time.
Please raise your right hand and state your name.
Carroll Martin?
Do you swear or affirm to tell the truth at this hearing?
I do.
Okay, again, now, you're aware, at this point in the proceedings, we're interested in determining your situation and whether you have special damages and are a unique individual with regards to this proposed project.
Yes, sir, I'm aware of that.
Okay?
Some of this information in this packet will help to visualize what my specific special standing would be.
Was this information presented at the time that the application for
There
standing
are
was?
some pictures that were included in my application to speak today, yes. There is additional information included in this packet as well.
All right, Amy, are we comfortable with accepting this packet? Okay, all right.
Will it also be able to be used when I am presenting information if standing is accepted?
Yes.
Okay. All right.
All right. How many copies do you have?
I have 5.
All right.
Can I ask just a clarification? I heard that this is for the purposes of standing, and whether it goes to the merits, it will be determined later. Is that what you just said?
Yeah, my understanding is that this information in her packet goes to the issue of standing.
Okay.
If the board finds standing, there's additional information in the packet which will go to the issue of the meritorious issues that the board has to decide.
As long as the compartmentalization is, this is only the question of standing, so if it comes in, it's not necessarily relevant or material or, something that I can object to for the merits. Because if she wants to get this in for standing purposes, we can have that discussion. I just want to be sure this is not being accepted for the merits.
This is only being accepted for standing.
Okay.
And for my clarification, if I am accepted as standing, that information I would be able to use for merits in a later date.
Assuming that it met the rules of evidence, yes.
Good afternoon, Mr. Chairman and members of the board. My name is Carol Martin, and I live at 20 Hollow Crest Way, which is part of the Hadley Park subdivision community. My property line directly backs up to the proposed project, as you can see from the first page of the packet I provided.
Ma'am, could you
Yes.
please speak into the microphone?
Yes,
Thank
I'm
you so
sorry.
much.
Can you hear me now? The proposed development introduces distinct localized structural risks to my home that far exceed any generalized public grievance. I am here this afternoon to provide vital site-specific information missing from the applicant's plan and to request that the developer provide clear binding protections for my home that are incorporated into the site plan and its execution. To illustrate the unique site-specific nature of my concern, you can look at Exhibit A0 in your packet. My home's foundation sits just 99 inches from the 20-year-old rear timber retaining wall with only 84 inches of clear space beneath the roof overhang and that wall at the shortest distance. The 7-foot structural retaining wall is about 4.5 feet from our shared property line, directly below an approximately 8-foot vertical ridge on the developer's side. As it stands, the current site plan relies on boilerplate, generic label 20-foot buffer typical. While a typical template works well on a flat, unconstrained land, it represents a severe risk on an 8-foot downward slope populated by mature trees directly above an existing home. At last Wednesday's recorded Zoom meeting, the applicant's lead civil engineer acknowledged he was unaware of the 7-foot structural retaining wall protecting 4 homes in the Hadley Park subdivision and confirmed that no final decisions have been made on tree preservation behind my home beyond the possibility of removing dead branches and dead trees. We are dealing with very large, mature trees on a steep slope. The root networks are the only thing binding the soil above my home. If those trees are removed and the roots are ground out without a site-specific plan, The lateral soil pressure will shift instantly, threatening to collapse the retaining wall with catastrophic impact on my home's patio and foundation. An engineering plan cannot safely protect adjacent properties if the engineers do not know those structures exist or don't account for them. That is why I believe that I have standing. As you can see from the picture, that Exhibit A0, that is the back of my home. You can see the slope, you can see how close that retaining wall is to my home, and you can see the property stake, which is approximately 4 feet from the retaining wall. So what stands between my home and whatever grading with the construction materials and grading that they are going to be doing is a very short distance, 4 feet plus about 8 feet, maybe 12 feet on an incline. And it was very disturbing and a concern to me that the civil engineer that presented at the neighborhood meeting was unaware of this wall. And so that's why I want to be able to speak today to make sure that specific stipulations are put in the site plan so that my home is protected. And there are other 4 homes that are there. I'm speaking for my home, but I'm certainly speaking to all of us who rely on that retaining wall.
All right, members of the board, any questions for
Well,
Martin?
I've got a question for staff for clarification. In her application, she says Hollowcrest Way. I'm looking at the maps here to try to reconcile where she is. And is that the same, is that Briar Creek Way?
No, the way the road works, I know it's confusing.
Yeah, it's a little confusing.
Briar Creek Way starts right immediately after Hollow Crest. So the first 2 homes that you see on the site plan, or which is why I included in the pictures the Hadley Park, the Hadley Park neighborhood plot. Number 1 and number 3 are Briar Creek Way. Number 20 and 21 are Hollow Crest Way.
Thank you.
Yes.
Paul, did I see you had a question?
yeah. I think you've made a very good argument for potential damages. And for me, it was going really well until you said, and the other 4 homes. Because, let me just finish, one of the requirements is that your damages be unique and be different from those other 4 homes.
My home is, the reason I said that is because I'm trying to be respectful of my neighbors. The neighbor to the left of me, her husband died suddenly, and she left the area, and so she is not there at the home. And so I was trying to be respectful. Mostly that's who I was talking about. My circumstance is unique because the retaining wall is at the highest there at my home. So the retaining wall obviously goes across, as you can see from the picture, across 3, 1, 20, and 21. But my section of the retaining wall is my responsibility, and therefore that is what I am here to talk about, is my section of that retaining wall.
Is the question, real quick, just for clarification again, the picture you have in here of the back of your home with the staking,
Yes,
is that staking your actual property line staking?
yes, that was there when I arrived, when I purchased the home.
Okay, thanks.
Joel, question for the,
Yeah, just to clarify what you just said, the retaining wall is on your property or the applicant's property?
It's on my property.
Okay,
The retaining wall was put in place by the developer when Hadley Park development was constructed, as a way to hold back the hill, the 8-foot hill slope that is there. It is only that section of that property line that has that retaining wall, because the slope comes down And so there are pictures there that show you where the slope comes down. So my particular house sits there at the peak there of that retaining wall.
If the retaining wall failed, who'd be responsible for repairs?
Me,
Okay, fine.
100%.
Yeah. Have there been any discussions with the applicant about the retaining wall?
I brought it up at the neighborhood meeting, and that was when I learned that the civil engineer was unaware of that retaining wall. So there have been no conversations with me since that point. And so I had some specific requests.
So I think that now we're venturing beyond the question of whether you're a matter of standing. So Joel, understand we all have curiosities there, but at this point in time, we're just determining. Okay. Any other questions let's hear, Mr. Justice, do you have an opinion on this request for standing?
Yes, and I actually have questions I would like to ask Ms. Martin in this context. Ms. Martin, did you hear, my name's Craig Justice.
Hello, Mr. Justice.
Hello. And you also heard that whether you have standing or not, we want you to be able to ask these questions.
I understand.
That correlate to your retaining wall, because there will be a very full discussion about the distance from where we're putting our buildings and what the buffer will be. So that will all come out during this process. So regardless of whether you have standing, you'll be able to ask questions. You understand that, right?
I understand that. I am more concerned about the construction and the, not that there will be buildings there. Obviously, I would like those buildings, as you see from my requests, to be 1 or 2 stories. I am mostly concerned about the soil and what will happen as a result of all the construction. There are pictures in my packet that show just from one construction vehicle that was just doing the land, whatever, the soil sample. My house was shaking as a result of that because they were pounding in the way that the ground is. And you can see from that picture the deep indentation into the soil from just that one construction vehicle. And so I actually left my home and went up, which I'm 69 years old. I went up the hill so that I could speak to the person that was doing that soil sample to ask if he was aware there was a retaining wall, and he said no. So that was another example of your applicant not being aware before they sent out someone to take a soil sample that my retaining wall was there.
So to be sure I understood what you had to say, is there was a truck that came out, they took a soil sample, and as a result, your house vibrated?
While he was doing the soil sample, the amount of pressure that he was having, that was being done by that machine, was so loud that my entire house sounded like it was happening right there in my backyard. Now, I'm not an engineer, so I can't say my house was vibrating, but I can certainly say that the sound vibration from what he was doing was so striking that I chose, as a 69-year-old woman, to go down the street, up the side of the hill, to go around to see if he could stop, because I was worried about what that was doing to my home.
Okay.
And when he indicated that he was unaware and had never been told about a retaining wall, that did not produce confidence that these processes that are taking place by your applicant have considered my retaining wall in my home.
Well, we're having a discussion about the consideration of your retaining wall during these proceedings. But let me ask you this. You bought your house when?
2015.
Okay. When you bought your house, did you check out the zoning of the property, of my client's property that adjoins your property?
I cannot answer what happened 10 years ago in terms of what that specific zoning was. I was aware because my realtor did check that there was a farm behind me.
Okay. But in terms of the zoning, do you have any idea that you checked?
I have no way. I cannot answer that question.
Okay. As you sit here today, do you realize the property that adjoins you is zoned EMP, Employment District?
I understand now, yes.
have you looked at the code and see that?
I'm not concerned about that, sir. I am concerned that while you do your construction, that you're considering the retaining wall and the mature trees behind my home, as you can see from the pictures, just one twig came down and completely took the entire back of my patio area there.
Ma'am,
So that's
we're-
what I'm concerned about.
And we will respect your concerns. I'm just trying to get through my questions with you, Ms. Martin. So for you to understand that for EMP zoning, for example, there could be an industrial facility.
Absolutely. Any type of zoning, I understand that, and I'm assuming
Counselor,
that they would be
are these
aware.
questions relevant to her request for standing or for your applicant's use of the land?
It has everything to do with whether or not she is being harmed by the project. And so I'm just, if I can, I'm only going to tend to ask like 5 minutes worth of questions, literally. But it does go to the question of whether or not she is demonstrating harm. Because what she's saying is really any development, right? Any development is going to harm me. And we have one of the higher intensity developments zoning next to her property. And she is contending that any development would harm me. Most developments don't have to go through this process of appearing in front of you, right? I can do an industrial building up to 50,000 square feet without even coming before this board. I could do single-family housing of greater density than what is being proposed without having to go before the board. All these things could be within 10 feet of her property line with no buffer. So I guess I've made my point, and I'm not sure she's aware of that, and I'm not sure anybody in the audience is aware of the fact that the zoning has already dictated a lot of things, and what we're proposing is very reasonable in light of what could be. So I'll just leave it at that, because we fully intend to demonstrate that we have considered property lines and separation in the design of this project, in the buffers, et cetera. So we will get to that in the merits. But the concern here is that if she says it's my retaining wall and she's concerned about development, then that would hold true for pretty much all development of the property next door.
Martin, do you have any closing comments before we consider your request?
Yes, I appreciate what the attorney is saying. I find what he is saying not relevant to this board proceeding because we're here talking about this specific development and the impact of this specific development on my home. And so I appreciate the fact I cannot answer. Did I know it was EMP before? Most homeowners are not going to get that information. If they're told by the realtor it's a farm and it's a working farm, they're not going to then go further and determine what the exact zoning is. They're going to rely on the realtor. So I can't speak to what happened in 2015 when we had this conversation. But I can speak to what's happening right now. And in terms of standing and particular harm specific to me, the very fact that that retaining wall was not known to the engineer at the time of the Zoom meeting, and when I went to go ask the soil, was not known, indicates to me specific harm because my specific home and the needs and the structural needs of my home were not considered as part of even the preliminary process of determining a site plan. And what I'm going to be asking for is that that specific information is accounted for and that there are specific things put in place to make sure that my home is protected both through foundation as well as the structure itself.
Thank you.
And Mr. Chairman, the only thing I have to say to that is she's making a conclusory statement of whether we considered her as a neighbor, and that is false. You will hear the testimony that our buildings are 50 feet away from this property line. We have a 20-foot vegetative buffer.
Understood,
And so-
understood. Again, we're venturing out into the
Understand.
presentation of the case, so Any final questions from the board before we deliberate? Quickly, Gabe, nope. Hearing none. All right, what opinions do my board members have regarding
I
this
mean,
request for standing?
Sure. I think the process is the process, which is the chance, the Zoom call to be heard, the chance to be here and be heard. I think all those things are part of our process so that people can express what's going on. So I think that is legit, and I think that's a great place for a witness. I don't feel like, though, there's special standing for this particular applicant, but I do feel like the chance to be heard and shared is here.
Yeah, I think, piggyback on Wesley's comment, I count roughly 13 or 14 lots that are just on this side of the project with a similar situation. There are 4 lots with a shared retaining wall. It's hard, it's getting hard for me to wrap my head around a special and unique situation with this property. I truly believe, you do have a case for consideration with the development process and the engineering that goes with the land development. But as far as a standing, I just don't see it yet.
I think I agree. It's not unique, but I do think this lady needs some consideration. But I do not think it is unique, but I do think it needs to, I want to keep an eye on it as we go through the process. I do think she's got something to be concerned about.
I agreed in terms of maybe expanding on the word consideration. It's influential in terms of the deliberations that this board will have at the appropriate time. And my fair fellow board members, that we all share that there's special consideration that we need to apply about her concerns. But yet they are not unique in that they are shared by her neighbors as well.
Right.
Is there any other comments to the counter? Any other thoughts, Mark? Good. Any concluding motion to consider?
Well, I'll make a motion, and I want to say to the board that I will never, as a member of this board, make a negative motion, because I strongly oppose negative motions, and I won't get into why. But the fact I make the positive notion in any particular case has nothing to do with how I'm going to vote on my own motion. Okay? So I move that we grant the applicant standing.
Is there a second? Not hearing a second, that motion is not to be considered. Is there a counter motion?
Motion to deny standing.
Is there? We have a motion and a second to deny standing. All in favor by show of hands? Unanimous?
Thank you for your time.
Thank you very much. Return to staff and our third request for applicant.
Sanders is the next standing request.
Welcome, Mr. Sanders. Please take the lectern and she'll swear you in.
Hello. Please raise your right hand and state your name.
Jack Sanders.
Do you swear or affirm to tell the truth during this hearing?
I do.
Welcome, sir.
Yeah, thank you for your time. I'm here in 2 capacities. One is my property. We share a property line with the subject property. My house backs up to the development, and also I am vice president of the Cottages at Glen Oaks Homeowners Association. So I'm here to represent myself and also our homeowners.
What question? 1 second. Let's get clarification from our counsel for the board.
Sure. Mr. Chair, Mr. Sanders can represent his own property, but he cannot represent the homeowners association. That would have to be done by each of those property owners or a lawyer hired on their behalf.
Okay, thank you. So the main concern personally for my house and how it adjoins the subject property is, if you look at the site plan, I don't have that with me. I'm assuming you all have all that, and actually it's out on this computer. There is a proposed 16 feet high retaining wall to be built to support one of the sections of the townhomes, and that is approximately 100 feet from my house, 33 yards. So from my standpoint, that is going to have a negative impact on my quality of life, having a 16-foot retaining wall 33 yards from my house. And I'm just very concerned with that. The other points that I have would be more generic conditions, regarding traffic and all that kind of thing. And I know that's not what we're trying to determine here. That's my position is why I should have standing, is that the proximity of that retaining wall to my property being only 33 yards away. It's 16 feet high, at least 300 feet long. It is a massive, massive retaining wall.
Questions from the board? Mark?
Yes. Is that from the front of the house, the back of the house?
The back of the house,
Back
which
of
is
the-
where we spend most of our time.
Joel?
Yeah, if you can mention again, what would be the detrimental effects, caused by you by having this 16-foot wall, as you said, it's about, 33 yards away?
33 yards, approximately 33 yards. So, a retaining wall is a retaining wall. It's a massive concrete slab that is going to be right there for me to be looking at the entire time, but anytime I step outside, that's what I'm going to be looking at. And we have 2 porches on the back of our house. We spend a majority of time on the back of our house, and it's a monstrosity is what it is.
Let me follow that up. The retaining wall, which you see, your concern is seeing the retaining wall that's already there?
That they're going to build. This is to be built, yes.
Okay.
There are retaining walls all over this county, and they're an eyesore. And I don't want to have that within 33 yards of my house.
Was the eyesore going to cause any damages?
I assume it won't. If you look at the site plan, it is right at the very edge of a stream that is between the 2 properties. It is a tributary of the French Broad. So I don't know if there's going to be any damage to that area or not. To my house specifically, no physical damage that I could foresee.
Paul? Yeah, I have 2 questions. First, a question for council. The definition of damages, do damages have to be like financial?
So what you can take into account is any factor you want to take into account, but the 3 big ones that generally come up are proximity, and I will say that none of these is determinative, like they kind of have to work together. Proximity, property value, if that's an issue, and then also secondary impacts can include use and enjoyment. So you don't have to put a dollar amount on that.
Okay, thank you. Then a question for the applicant. Are you the only household who's going to suffer the damages that you're describing?
No.
Thank you.
No, I'm not.
Mr. Justice, do you have any questions or a statement to bring forth?
And the same thing that I've said to the others, you will have an opportunity to get into the weeds about questions and distance. I think you've said today this wall is 100 feet or so away from, is that from your property line or from your porch?
From the property line.
Okay. Do you have a retaining wall on your property?
No, I don't.
Okay. And so you're not aware of the specifics about you mentioned a stream and how much buffer is really between you, vegetative buffer between you and this wall that you talk about. You don't know the specifics about.
Well, there is vegetative buffer right now, but in the wintertime, all the leaves go away. It's just, you can clearly see the pasture this is going to be built.
Okay, all right. I just, from this, I don't have any more questions here, but it is a slippery slope, no pun, on the wall. If standing is based on the fact that 100 feet from me, I can see something that is 16 feet tall. I think he said, well, I'm not sure I have damages, and he mentioned that he shares the same visual thing with others. So I don't believe he's demonstrated a unique damages for standing purposes. But again, he's going to be able to ask the questions that others are going to be able to ask. But I don't think he's demonstrated standing.
Just for clarification, do you understand what this could potentially go to at the point in time when these witnesses come forward with a lengthy list of questions that you've been willing to state that your applicant and yourself are going to answer?
So and this is up to you in terms of process. The whole point of process usually for us is who's being harmed from a due process standpoint of party status. And what I'm saying as the applicant, we're wanting to answer questions. So Warren Sugg will be our first witness, right? So he's a civil engineer. He's going to go through all this. So when he gets done and you're finished with your questions, I'm perfectly fine with any one of these 4 individuals who have signed up to ask a question at that time, if they like. And I know it might be unusual because I think I'm offering more than what is typical in this process. Or we can wait to when they come up as a witness, and it's after all things. I think it'd be good contemporaneous with Warren for him to be able to ask questions. That's what I'm just offering as a transparent process.
Any other questions regarding this gentleman's request for standing? All right. Hearing none, let's move to dialogue among board members. Your thoughts?
I think my thoughts are the same as the last witness for candidate for standing. There's not some unique damages presented in this. I think it's absolutely warrants being a witness in this hearing, but does not rise to the definition of meeting requirements for standing.
Any alternative opinions worthy of reviewing?
I'm just gonna parrot him, what he said.
Okay.
Yeah, I think it's relevant, but I don't think it's unique.
No, I tend to agree. Even Mr. Sand, you noted in this county there are a lot of retaining walls. We cannot have construction without retaining walls, and that is our reality. And so I tend to agree with Gabe and Greg. Any other thoughts or a motion?
I'll make a motion to deny standing.
Second.
There is a motion and a second. All in support of the motion to deny standing, aye? Aye.
Aye.
Any opposed? Thank you, sir. You will have an opportunity at the time to come forth as a witness, as well as our arrangements here with council to respond to questions that may come up following the engineering report by Mr. Sugg. Thank you.
Next application, we have Francis Sterling.
Francis had to work. She gave me her statement that she wanted to make as someone with standing. So I am also a homeowner that borders the property. I sent an email.
So, sir, if you can please stand up to the dais. You're fine.
My first rodeo.
And sir, are you wanting to assert standing? You would not be able to represent her.
I was going to do both. I was going to ask for standing since I didn't understand how to file an application.
All right. So
And also, I have her statement here, so I was going to represent her as well if it was allowed.
So you won't be able to represent her, but if you'd like to assert standing, we can swear you in.
Oh, okay, go ahead.
Please raise your right hand and state your name.
Carl Kadelka,
Can you please spell that for us?
Koudelka.
Thank you. Do you swear or affirm to tell the truth and nothing but the truth?
Yes.
Thank you.
Welcome, Carl. Again, understand that at this point in time, your plan to present your neighbors or friends' binder statement material, unfortunately, you can only speak for your individual request for standing, and you should be focused on how your particular situation is unique and special in terms of damages that you may have to deal with should the applicant move forward.
I understand. Okay, so. How's this? Hello? A little closer? Yeah. Oh,
Thank you.
okay, I hear it.
Thank you.
All right. Okay, I live at 20 Asher Lane, which, if your maps show it, shows that it goes down to the stream. I'm 2 doors down from Jack. I have a total panoramic view of the farm bank, and it will now turn into about a dozen homes and a retaining wall, 16 feet high, soaring up the hill. So I think that is going to dramatically lower my property value. And for that reason, I request standing.
Have you had any professional assessment on the impact to your property value should this project move forward?
No, I have not. I didn't realize they would have years to plan their project, and I would only know for a week that I had to come up with this sort of detailed information. Perhaps you should give us more time now that we know what we have to do.
Mr. Justice?
Can I call you Carl?
Sure.
All right, Carl. And you did hear, I'll say my spiel, that you can ask any questions at a point in time after a witness is done. You understand that?
I understand we can ask questions. I haven't heard, so, what value is a question? Because is our question going to affect anything? The answer to our question?
How it affects you is a personal choice. So I can only tell you that you will have an opportunity.
Speaking as from the board, it will affect the board members' decision on the outcome of the case.
Thank you. Okay, that's sort of what I was looking to hear.
As we referred to earlier, the consideration that we all have agreed to take into account was from previous applicants for standing and their concerns, which we will take into account.
So before you vote on whether to proceed with the project, you will hear the witness and the interaction, which the attorney has offered. Okay.
So would you like to withdraw your motion or your standing and just be a witness for us?
Like I said, we've known about this for a week, and I'm not a real estate person. What am I giving up by giving up standing?
You have a question, or are you prepared to answer his question? I think I would turn to Amy to answer the question of what is this gentleman giving up?
Particularly appropriate for me to give legal advice to somebody who's other than the board, but I would say a person upon whom standing is conferred has the right to participate. I don't know what's happening. Has the right to participate as though you were in the case. You'd sit at the table, you'd ask questions of witnesses, you could object, you could do everything that basically somebody who was involved in the case could do. If, depending on the outcome, you could appeal, things like that. Beyond that, it's probably best that you consult with private counsel if you have other questions about that.
Okay. No, I'll appeal first. I will apply for standing, but,
I don't have all the evidence because I didn't know I would need it, and I don't think it's fair that we only have a week and they've had months.
Other questions?
Yeah,
Any
Mr.
follow-up
Chairman,
comment?
can I ask, Carl, the view that you have said that you will have, this is shared by others in your community, correct?
Not really. My entire view is panoramic of the new development.
So-
Most people have much more of a buffer.
So the neighbor that just talked a second ago, his view is not similar to your view?
The trees of the buffer are much closer to his home than they are to mine. If you can see the layout, there's a big basin for water runoff behind my house, which creates like a pasture of a few acres. And then there's the tree line. And then there's going to be a huge retaining wall with houses up above it. So I think my view is unique.
Do you have anything besides aesthetics, the view, what you see? Do you have anything else to offer in terms of damages?
Only if any of those trees disappear.
All right, board deliberation, thoughts on this particular request for standing? Leslie, you're leaning forward.
Yeah, I mean, I feel like we're in the same situation we've been on, you know, it's something to take a look at. I'm interested in hearing the engineer. I want to see some more about the details on the plan that we'll consider and then hear more comment on it, so.
Any differing thoughts on this application than on the others, gentlemen? No. Therefore, I think we're at a point for a motion. Joel?
Yeah, I move to deny standing.
Second.
We have a motion and a second to deny standing. All in favor, aye.
Aye.
Any opposed, nay? Thank you, sir. You will have the opportunity, as previously noted, to participate as a
I understand
witness.
that.
Thank you. At this point in time, I'm looking, do we need to have a brief break before we proceed with the applicant's presentation? Okay, let's take a 5-minute break, and I'll hold it a little tighter to 5 than Andy usually does. I'm not running.
Is that a 30-foot buffer on that stream?
It is.
Is that 30 feet from the center of the stream out in each direction?
I believe
Or
so.
15 feet out from the center? of the
He's going to talk about that here in about 5 minutes. Yes, sir. I am, Mr. Chairman, and just as a point of, before I start, and I always do this, is, obviously if, Lord knows if this thing had to go up to a court, we all want to make sure that the court reviewing body has the complete Buncombe County zoning ordinance and the complete Buncombe County zoning map. So I just want to be sure with your counsel, it's all right, we just deemed that to be admitted into the record, your zoning ordinance and your zoning map. So I usually make that statement.
Be naturally a part of any judicial review, but certainly it can't hurt for this body to take its version of judicial notice.
That's great. And then the last thing is, since retaining walls, last time I was here for you, I think we had a big old discussion about retaining walls. So you also have a retaining wall ordinance. I would like that to also be part of the record as well. All right, thank you. Our first witness is Warren Sugg.
Please raise your right hand and state your name.
Warren Sugg.
Do you swear or affirm to tell the truth during this hearing?
I do.
All right, Warren, why don't you just give a brief overview of who you are and how you correlate to the project, and then we'll move forward with some documents.
My name is Warren Sugg. I work for Civil Design Concepts. I'm a professional engineer in the state of North Carolina and South Carolina. Been working here in this market for approximately 12 years and over 20 years in civil design work, all during that time in land development projects. I got my degree from North Carolina State University way back in the 1900s, and been doing it ever since.
And for this project, how do you relate to this project?
I am the civil engineer of record on it.
All right. And for purposes of this hearing, had you prepared an affidavit with a report for consideration?
I did, and that was submitted to staff, and it looks like this one that's going to be Exhibit 1.
Yeah, so, Mr. Chairman, we'd like to offer this into the record. I'll hand to the clerk. I believe one was uploaded this morning for sure, and so I'd like to tender this as part of the record. And Mr. Chairman, his written affidavit does contain his complete resume that demonstrates his expertise and professionalism. And at this time, I would like to tender him as an expert in civil engineering.
Hearing no objections, so tendered.
All right, thank you. Warren, go ahead and describe the project to the board.
Thank you. So the project that's before you today is bound by a couple different parcel numbers. Those parcel numbers are both found in the application, but also in the site data block. The existing condition sheet is C101. You'll see those pin numbers up in the top, and this is roughly about a 30-acre combined set of parcels. There is some existing structures that are there as well as some existing connective driveways. Those would be removed as part of this plan. We do have a few areas where we've demarcated some very light stream and wetland impact, and I'll go into further detail on that as we talk through the plan. But those are the removal or the demo portions of it. There are some fencing items that are out there on site as well that would be removed. As we get to sheet C201, which is the site plan sheet, the connection points for vehicles are both along Glen Bridge Southeast. We have our first connection that is on the northwest corner, and that road comes predominantly north-south. Both on the right and left side of that new road, you see townhome units. There's a total of 191 townhome units here. The other connection, which is a little further to the east on Glenbridge Southeast, also comes into the site and abruptly kind of comes to T, where you can go right or left to some other units. On site, as well as the sidewalks, the 199 or 191 units, there are driveways to each of these units. There are garages in each of these units. There are guest spaces. Those driveways and garages and guest units total of 501 total parking areas or parking spaces, 241 of those being in driveways, 245 of those being in garages, and then there's 12 guests. We have an amenity package this here, so sort of the middle of the site, the biggest of the buildings that you see there in gold on that sheet, that is the clubhouse, the leasing, the fitness. It has a pool, has a recreation area, playground. That is the sort of central fun area for everybody that would be here. We also have a number of different stormwater controls. You'll see some blue shapes, the biggest one being on the south end of the site. That's where the predominance of the stormwater really wants to accumulate. So we've got a number of those. As you flip, I promise not to make you do too much flipping, but if you flip to 501, there are some below-ground storm systems as well. We expected those would be most likely StormTech, which is a good infiltration device. So a good bit of stormwater controls here to account for the increase in imperviousness there. We, as part of this process, normally have to do a water and sewer commitment letter allocation. So we have those back from the City of Asheville and from MSD. City of Asheville connection to water would be out along Glenbridge Southeast. We're lucky that we have sanitary sewer that's already along our southern border, so we can collect up our sanitary sewer on site and then make that connection. So this project proposes and doesn't need any off-site improvements for water and sewer. And a lot of probably what most of the neighbors want to talk about is we do have a 20-foot landscape buffer that you can see in green on that sheet along that northwestmost corner, and then also along that eastern edge. And we try to do that intentionally up against where there is some existing vegetation that's going to be saved. There's places where we can add to some vegetation, but it's also just where we have those neighbors that are closest to us.
So Warren, before we get into the buffers and the placement of the buildings and the separation from property lines, because that a lot of the witness asked about that, let's go back and touch on some things you just said. In terms of the density at 191 units, how does that compare to what EMP allows, since that's the zoning district?
Yeah, so EMP, 12 units an acre is your allowance there, so we're roughly about 30 acres, so that'd be about 360 units that would be available. We're at 191, which puts us at about 6.5 units an acre, so about half the density that would be allowed here. And even if you looked at it as a single family by right, it's 5,000 square foot lots, so well and above 250 lots would be available here.
As of, if you did, in an alternative universe, if you had presented a plan as a single-family subdivision, that would be the density that you could put on this property.
Correct.
Now, in terms of the use of the property, it's a residential use, correct?
Correct, townhomes residential use.
Okay. And in terms of the height of the buildings, why don't you walk the board through regarding the height of these residential units?
So the architect and the owner did a great job, and you can see some of the architectural sheets as you get to A1, A2, A3, but I'll give you the summary. There's a mix of 1, 2, and 3-story buildings here, and it's not even just a building as all of one type. It's mixed even among the buildings. So those heights are as low as about 20 foot tall to as tall as, I think our tallest one's 30, let's see here.
It's the 3-story, which
Yep.
would be 40.
It is 40, flipping to the right one, 43, which is still well below the 90-foot EMP, which would be very large.
So point out on the plan where these structures are placed, because the 3-story structures are buried deep into the property from just a cursory review of the plan, but walk the board through how these things are placed on the property.
Yes, so as you flip to those A sheets, they've done a great job of color coding where you see the different types. So for instance, if you went to A5, you'll see the 43 tall units, and those are predominantly all down here at the very south of the project, which is an area that really hasn't been spoken to today at all from. Excuse me? A5, which, is that part of the PDF file, or? Should look like this.
In the site plan document? Yeah, it's toward the back.
Yeah, I'm sorry, sheet A5 is on the PDF, page 12.
So those pages, if you look in all the A sheets, those do a really great job of color coding where the unit is and also what the unit is. So you'll notice A5, those are on the southern edge of the property. Those are the 3-story, those 43 feet that we talked about. As you flip to some of these other ones, A4, that shows the predominantly 1, 2, and 3, or actually 1 and 2 stories that you see along the edges that I think most of the witnesses are interested in, and those are 32 feet high.
And just for a comparison, in terms of the residential districts that the neighbors are zoned, being R2, R1, the maximum allowed height for residential structures in those zones is 35 feet. Is that
Correct.
right? And so what is being proposed next to their property is a lesser height than what a structure can be as of right in those neighboring zones, correct?
Correct.
Now, in terms of stormwater, you had talked about that a little bit in detail. Is the stormwater plan compliant with the Buncombe County standards for stormwater?
It is at the conceptual BOA level, and as we all know, as we get through the end of this, then we have to go into much more detailed calculations and plans. And those reviews, not only with staff, Buncombe County, MSD, City of Asheville Water, happen post-entitlement.
In terms of the playgrounds and amenities, you have a special sheet that provides extra detail about a rendering of this area. And I know Ms. Morisani usually likes to see the renderings. She's not here, but we do have a rendering of the playground.
So that sheet, hopefully you guys have, looks like this.
And I'm going to go ahead and mark that as Exhibit 2 to turn in when you get done. But that is a rendering of the amenities, including the playground area.
It is.
And there is actually
Get you another page here.
another rendering of the actual playground equipment.
Mhm. Looks like this.
Yes, we will. I'll mark that as Exhibit number 3. And so that Exhibit 3 is a rendering of the actual proposed playground equipment, correct?
Yes.
And this is part of your packet, but, Mr. Chairman, we'd like to go ahead and introduce Exhibit 2 and 3, and then I'll hand it up.
Those are additions to what was already been submitted?
Yes, sir.
Okay, so noted and accepted.
In terms of the parking you had mentioned before, does the proposed parking plan comply with the Buncombe County standards?
It does. 1.75 to 1 is the required, and we're 2.6 to 1.
All right. Now, in terms of how this property, the zoning of this property overlays with the zoning of the adjoining properties, let me show you what I'll mark as Exhibit 4. Is that appear to be an accurate copy of the zoning for this this surrounding area?
Yes.
And do you see where the property in question is identified with an asterisk?
Yep.
All right, we're going to go ahead and mark that as Exhibit 4. Is that right?
Yes.
Yep. Mr. Chairman, I'd like to go ahead and offer this as Exhibit 4, this zoning rendering.
No, hearing no objections, so noted, accepted.
All right. Warren, since a lot of the witnesses asked about placement of houses, and one lady asked about her retaining wall, and a lot of questions about buffers, you have a diagram showing sort of where the neighbors are in relation to the project, right?
I do. We did a color aerial version, which we overlaid onto C301, just so that we could have some names of some neighbors as well as just some proximity so that we could all see that in real time.
Mr. Chairman, do you happen to have that sheet? Again, this was uploaded.
Looks like this.
C301?
Yeah, and it has an aerial.
Yes.
Okay.
That's a part of the original packet. Should be the same document that we've been referring to. Looks like it's page 4 of 15.
Well, it's a special supplemental sheet. So what
I think he
page,
slipped
Jason,
line.
what page would that be? That supplemental aerial showing where the neighbors are?
So when you say...
Yes, we'll pass it along. Well, let's go ahead and we'll mark this as exhibit
Yeah, but they're
number
not labeled.
5.
I think it's what he's labeled houses. Oh, for
And-
clarity, so you're going to provide us with a version of C301 that has the neighboring houses labeled by owner?
Yeah, has the neighboring houses circled, and he's going to walk through it and explain it. But you have this sheet that was uploaded to you.
I'm sorry, it was originally there, and then we had an updated site plan set, and then the replacement was replaced back. So we'll get that uploaded as a supplemental document.
All right, so it's being uploaded as we speak, apparently. So,
You take off this. I got it electronically. Okay.
We had,
I'd like to introduce Exhibit 5. This is what's going to be uploaded here shortly, but this is what the witness is about to testify to.
accepted.
So while that's going on, Warren, why don't you, starting at the northwest corner where the first two folks that applied for standing are located, why don't you walk through sort of the general concept plan of separation of buildings and buffer?
Yeah, so as you look at that westernmost boundary where those existing houses are very close to the property line and very close to the wall that was there, using aerial and looking at the survey that we had, it looks like a lot of those existing 4 or 5 structures, 6 structures are about 12 feet from property line to the residence. There's about somewhere between 4 and 7 feet from property line to the wall, the existing wall, the wooden wall that I think, as mentioned, has been maybe there for about 20 years. And then coming over to our site where we can sort of control things, most of those structures are 50-plus feet away from the property line. So if you compare 12 feet their side, 50 feet our side, and then our wall is roughly about 35 feet from the property line, whereas theirs is 4 to 7. The other thing that I think should be noted is we have a landscape buffer there. That's an undisturbed area that we don't show any grades into. So the vegetation that's there should remain there. The only caveat is if there's anything that's dead, it should be removed. But I do think that proximity discussion is very important here, and we're significantly further away.
So for purposes of EMP zoning and for purposes of residential uses in particular like this project, does the county require any type of buffer?
They do not. Residential to residential is not required.
So again, that what is being proposed is an undisturbed buffer of 20 feet in this particular area.
Correct.
And then you indicated that the actual proposed buildings are approximately 50 feet from the property line.
That's correct.
And in terms of the setback for EMP, the setback for a side is 10 feet.
Correct.
for buildings and structures in your 50 feet.
Yes, sir.
All right.
May I ask a question? I
Yes,
just
sir.
want- To put this in what I've seen, the testimony I've heard from some of the witnesses, Ms. Martin, in the back of her house, there appears to be some large oak trees. So if my understanding is correct, those are going to be left in place as part of this buffer.
If they are within the 20-foot non-disturbed buffer, then yes. If they're on someone else's property, I can't control that, or if they're outside of that 20.
Correct. Okay, thank you.
All right, if you would walk the board through the more south west or towards the Asher Lane property owners.
So the area there's a stream with a stream buffer. That stream was delineated by a Streams and Wetlands consultant. Buncombe County has a standard 30-foot top of bank buffers that are required there. So that buffer, which is the SB line that you can see, is shown. We don't have any disturbance within that SB area. We do have that 16-foot wall, but I would say that that 16-foot wall is only 16 foot at a very small section. And then as you follow it down, it actually goes down to about 6 feet. And as you turn the corner, it would go from 16 to 0 fairly quickly. So I think there was some testimony or some witness that it would be 300 to 400 foot long. It is a long wall, but it's not 16 foot the whole way.
And in terms of the Buncombe County ordinance that covers retaining walls, there is an ordinance specific. We've actually entered it into the record. The height where the county starts regulating retaining walls, isn't that 20 feet?
20 feet is where you have to tier them and have multiple walls. If I'm not mistaken, 6 foot, 5 foot, 10 foot. I think it depends on, yeah. Over 10 is where they get into it, and we can't have any that are within the setbacks unless we ask the BOA for that.
I got you. And I think Ms. Martin testified that her wall, retaining wall, is 99 inches from her property line.
That's what she said.
Yeah. And so when you said a 30-foot buffer, are you saying from center of stream or where are you from bank?
Top of bank.
Okay.
So if a stream is 1 foot wide, then you would have 61 foot of buffer to buffer. If you had a 10-foot wide stream, top of bank to bank, you'd have 70 foot.
So for each side of each bank.
Correct.
Has a 30-foot offset as a buffer.
Correct.
And in terms of then relating to the Adler Lane properties, where the first building appears is approximately how far?
It's approximately 65 feet from property line to the wall, and then from the wall to the actual structure is approximately 15 feet additional.
And for purposes of vegetation, with this stream buffer that's 30 feet either side of bank, are you touching the vegetation in those areas?
Completely undisturbed.
And the gentleman that spoke last, who said he had the panoramic view, from GIS, in terms of his property abutting, his property abuts what?
It looks like to the rear of that property, it says Cottages of Glen Oaks HOA Incorporated. There's one very small tip, maybe the easternmost edge of his rear property line that touches the property line of this one. I'm going to estimate it's less than 5 feet.
And so most of his boundary then borders what appears to be his HOA common area.
It's a HOA. I'm not sure if it's his or somebody else's.
In terms of your affidavit, you opine at the very end of your affidavit that based on your experience and expertise in civil engineering and your knowledge of this project and the ordinance requirements for a special use permit, that it's your opinion that this project does in fact meet all the requirements for special use, correct?
Correct.
That's all the questions I have, Mr. Chairman.
Joel?
Yeah, the issues, let me talk about the retaining walls, and I don't know if you can answer them, but I know you cited all the zoning requirements for this piece of land, that basically, to me, it came off, well, we don't have to do this, we don't have to do that, okay? And I guess as a good neighbor, okay, to, you know, with the issues that came up, would you be willing to look at the vegetation again? And because I have a concern, removal of trees, if you're not building right in that spot, take out the root system, and we saw what happened with the hurricane. That causes erosion. So that would be one thing, and discussing with the neighbors, you know, maybe increasing vegetation and buffers, even increasing it with trees that don't lose their leaves, you know, because, you know, I realize visual is not, you can't make a case for that. If that's the case in my neighborhood, I would have appeared before this board several times. But in your response, you know, if you could work with the neighbors on some of these issues, I don't see where there'd be any problems.
Well, when we had the community meeting, there were references to why are you here? And so I'm not sure we'll be able to satisfy everybody, Joel, but we do have a vegetative plan that is more specific than the natural buffer along the northwest, right? That 20-foot, we've got plantings going on there, and that was part of what has been uploaded as well, right?
That is correct.
And so I'll mark that as Exhibit 6.
Exhibit 6 accepted.
So, you walk through that, what are we leaving versus what are we proposing to plant?
So a large area, or most of that buffer along that area is untouched. So we could really debate for a long ways whether it's more impactful to go dig a bunch of holes and put in more trees. We've shown on there the ability to supplement that 20-foot buffer with 5 to 6 foot tall trees, evergreens, an on center, 5-foot offset, that kind of thing. So we can do that. It will certainly help supplement it, but that's, I think, what we could offer up. And there's all the vegetation that's going to be there is going to continue to stay there unless it's a dead tree.
So to what you were saying is, to the northwest, the folks the first two speakers, you have things that you're planning as demonstrated on Exhibit C. So you're supplementing in those areas with plantings, correct?
Correct.
For the folks the last two speakers, you've got a 60-foot wide, at least, vegetative buffer, 60 feet, that you're leaving in place, in part because of the creek that's there, correct?
Correct. And not planting that area.
Yeah. So we are open to reasonable conditions. I say that every time I come before you. We are open to reasonable conditions. And so there will be continuing dialogue with the neighbors post this meeting. So we would want direction. If you said, well, please do X, Y, and Z. I don't know if you remember, Mr. Allen, the last project we had, there was a request that deal with some glare, and we worked through that. There was some requests about side crossings of the street. We dealt with that. So we're open to having that discussion through this process. We do believe that with what Warren has said, that we have taken into consideration our neighbors by taking the standards that are for EMP that says 10 feet setback, and we're 5 to 6 times that. And in areas we're supplementing the nature that we're leaving in place. So we're open to reasonable conditions. I hope that answers your question. So the answer is yes, we're open to a discussion about it.
So if I could interject, could you speak to, I didn't hear that you specifically spoke to what this exhibit number 6 outlines in terms of 2 rows of evergreen. Could you
Yeah,
provide
he
that information for everybody?
Took off, so I don't have the exacts in front of me, but I know it's 5 to 6 foot tall. It is 5 foot on center, offset 2 rows, so you're trying to have those kind of soldiered each time. So that's what's being shown there as a possibility, as just a supplement to what's existing there today.
So is that a possibility, or is that
It's in the submitted
a
plans.
request, Joel?
It was submitted as part of the supplement to the application to show that we're willing to do that, yes.
So to your point, Joel, to understand how this is flowing here,
Yeah, because I would like to see some conditions, in there about, of course, working for the neighbors and ensuring that there's modifications to the buffer to help resolve their concerns. The other question I have too, that kind of came up, was the retaining wall and fear of that could be damaged. And, I don't know if this could be a condition, but if there's damage and it's on a property and, could be proven,
Well,
would the
that's-
applicant
that-
address that?
That's going to be the thing, right? We would have to do assessment of the baseline condition of that wall. And at the end of the day, there is civil liability that will exist regardless of what you do. If you put a condition on us that says we're responsible, then you are prejudging that wall. And it could already be damaged in its natural condition. And that would be a slippery slope, right? If you did that for all developers. So again, the consideration, Joel, is how far is our development? Where is that occurring? We're off 20 feet of an area we're not disturbing, where the ordinance doesn't require really any feet of a buffer. And a building setback that's 10 feet, and we're 50 feet. So we're already trying to consider and respect the neighbors in that regard. So I would respectfully ask not to impose some indemnification on us in this process.
Understood.
Okay.
Understood. That's outside the scope of, and that will be remedied through another legal proceeding should it come about.
Yeah. Who owns that 20 feet?
It would be retained by the property owner. It would be managed by the management company.
Okay. And I understood what you said. Would you take the responsibility as a condition with your civil engineer to do an assessment of that retaining wall?
Again, you're asking us to head down a ground of indemnification and assessment of somebody else's property. And with all due respect, that would be a slippery slope. So I hate to say no to you, Joel, but I'm going to have to say respectfully, no, we would not do that.
Okay.
That wouldn't even correlate to a standard in your ordinance for us to be responsible for that.
So then the property owner basically would have to take legal action if she felt the damage was caused by the developer.
Correct. That exists in the universe already.
Okay.
So, we could talk about, obviously, construction process, hours and things of that nature, but to make us responsible for private property in that respect, respectfully, we can't do that.
Okay, so you could talk to possibly property owner just regarding concerns of the construction. and whether
We're
it
going to
have
do
any
that
adverse-
post-meeting anyway.
Yeah.
Just, that's the courtesy that any neighbor would do.
Okay.
Question, Warren, on, it's labeled as building type 7, building number 24. Reason I'm focusing on that is I don't see where there is an explanation of what style that building is. And again, it's along the questionable northwest edge. It's the grouping of buildings in the middle.
Yep.
What is the design of that? Is that a two-story, one-story? And it is immediately behind Ms. Martin's home.
I will have to ask the owner. I feel like it's the exact same thing as this A4 with the mix of 1 stories on the end and the 2, but it doesn't exceed a 3 for sure.
So you're seeing what I'm seeing, it is not labeled. So that grouping of buildings is not labeled in terms of its
The
design.
color code on A4, it does not show a color right there. It does show the one to the north of it, the south of it, and the 2 that are just south of that as well.
And is there a reason, or is that just an oversight?
I think that someone didn't get their crayon out. So can you come up here, please, and be sworn in to answer that question?
It's 1 and 2 story. It's the same, like next to this. Can you talk about the cut that's happening in these buildings? But yeah, the only 3 story. Okay. Those are all 1s and 2s. Okay, so we got confirmation. Those are 1s and 2s, so they match in the height of the ones that are to the south and the north of them. The only 3 stories that are on any of this site are the ones that are shown on A5, which are at the far south corner of the building, or corner of the development.
So for simplicity's sake, they should be color-coded exactly the same as the adjoining, the immediate properties to the north and the south.
Yes, sir.
A question regarding preliminary activities. I believe Ms. Martin at length discussed the need to go up and investigate what kind of vibrations and sounds were being prepared. Can you speak to what likely that was?
That was a geotech firm doing site bores. So anytime you're doing a due diligence of a project, you have them go out and drill down to understand what the makeup of the soil is, any kind of rock, unsuitables, groundwater, things like that. So that was the investigation that was happening.
And would those borings be in the proximity of the planned foundation?
They are, yeah.
So
They're throughout the site where we expect our cuts and our fills to be, and also where we expect stormwater to be, just so we can understand groundwater and soils and rock.
And how would those noise and vibrations compare with the construction noise and vibration?
I'm not a decibel expert knowing that, but construction's construction. This is investigation. I wasn't out there on site, but it's likely they had a truck rig with a drill bit on the back. It was probably 8 to 12 inches or maybe smaller. It was digging down the ground, and they have soil samples that come out of it.
And the owner representative is present that in terms of construction-related questions that we can get into when he's here.
I have just one more comment. Would it be appropriate to, and acceptable to the applicant to sort of, as a condition, to try to make every effort to leave the old growth trees in the buffer area? I mean, I hear the comments that new vegetation will be planted, but I don't want to think everything's going to be clear cut. They're going to take a big track hoe in there and clear out those stumps and then plant this new vegetation. I would rather see the old trees left in place, the older trees.
I believe, and Warren, correct me if I'm wrong, the plan was to leave that 20 feet undisturbed, except to the extent that you have a dead tree that would pose a risk. So it would be left undisturbed. The plantings would be up to a little bit of a professional in terms of placement so that the new planting doesn't disturb the old growth. So it's just to provide a supplement to what's there, but it's not intended to raise that site and then plant new things. It's intended to leave it in place, certainly the healthy specimens. Is that right?
That is correct, and it's a twofold thing. We want the trees there. Views are both ways.
You're good with that, Mark? Okay. Any other questions for Mr. Sugg?
This isn't for Mr. Suggs, but is this the place where the 4 applicants for standing ask questions?
Well, we'll go to the gentleman who offered that. What was your idea from a procedural standpoint to wait
Yes,
until?
I'm done asking questions of Warren. If you're done asking questions of Warren, this is the opportunity for them to ask questions. And I guess if you just go down the list and start with the first gentleman, if he wants to ask any questions, that seems like a good order of things.
So the-
Procedural, do you want me here, or do you want me somewhere else?
Just stand right there
Okay,
and,
perfect.
or you can come over here and share this microphone, however.
So before we get started, I just want to say to the witnesses, realize we got a lot of folks here for a lot of the other cases. So if you have some specific questions that you did not hear answered by Mr. Sugg, please ask them briefly, and Mr. Sugg will give us the answer, if he has the ability to do so. Yes, sir. Yes.
Do that.
Yeah, you can go right there.
Me?
Hear you
Can you hear
now.
me? So my questions were answered about the buffer and everything. It seems like those were,
Okay.
I got the answers there. For the engineer, there is a drain pipe at the northeast corner that comes under Glenbridge Southeast from the landscape company. It's a 12-inch pipe. And it drains out into the woods, which of course, softens the ground and trees fall there all the time. My question is, are y'all going to redo that? I know the DOT handles the pipe, but the part where it comes onto your property.
Yeah, so that and any other places where we have pipes that are coming onto the property, we will have to capture that, whether it's overland flow through like grass swell areas or connected with
Right,
actual
'cause
boxes and pipes.
There's no ditch for it to run in either way, down the road or anywhere. It just goes right in between the trees. And I just wanted to bring that to your attention if you haven't checked it out.
Yep.
That is, and is this is this neighborhood part of a real estate investment trust? Is that the type of neighborhood it is?
Okay, I was going to say, again, we're going to keep our questions focused on what it was that
Okay.
brought you here.
'Cause I know it's a new style that's all lease development. Is that right? Are they?
Well, as you may realize, that doesn't tie to a condition or a standard in the ordinance. This is being offered as a rental community of townhouses, so.
It's just a new style.
Well, some people don't like vertical. They like to live in
Right.
sort of, it's a different style in that respect, but it's a rent, it's offered as a rental.
All right,
Okay.
any other questions specific to Mr. Sugg, the
You
engineering
answered
report?
Thank you.
Yeah. Thank you.
Anyone else that have their questions unanswered or have any questions that were prompted by Mr. Sugg's expert testimony? Yes, sir. Come forth.
Thank you. So, yes, there's been, I've gotten more clarity, and I appreciate that. Couple of things that I have, and I don't know if they're appropriate for this meeting or not, but I had questions regarding the lighting and light pollution. Is that something that could be answered now, or is it for some other?
In terms of our lighting plan, that's a very appropriate question. I do think pollution is in the eye of the beholder a little bit, but in terms of the lighting plan, go ahead and talk about that.
So Buncombe County has ordinances on all lighting things. The detailed lighting plan will be detailed drawings, just like all the other detailed drawings that'll come later. They'll have to be reviewed by Buncombe County, and they have to approve or deny those.
So we intend to meet the Buncombe County standards that deal with lighting.
And is that standard similar to something like a dark sky certified fixtures? Because this is, once again, I will be looking at all this lighting.
Understood, but I've heard the applicant state that they're going to comply with all regulations, zoning requirements, Buncombe County standards for this property and the lighting for it. If you've got questions about what that is, it'd probably be best to go and look at what those standards are and
Okay.
see if they answer your question.
Okay, thank you. And then the traffic analysis that was done. That, I'm simply not educated in it. It's showing one.
Mr. Saunders, can I interrupt? This witness is civil engineering. We have a traffic engineer coming up.
Okay.
And so if you want to ask questions relating to traffic, you may want to hold off.
Okay.
Yeah.
That's good. That's
Yeah,
all I have
thank
right
you.
now then.
Yep, thank you. All right, Mr. Sugg, thank you very much. Mr. Justice, your next witness,
John Palmer, please.
Mr. Palmer.
Hello. Please raise your right hand and state your name.
John C. Palmer.
Do you swear or affirm to tell the truth at this hearing?
I do.
Hey, John, go ahead and introduce yourself to the board and just give an overview of your qualifications and your relationship to the project.
Okay. My name is John C. Palmer. I'm a certified commercial appraiser, also an MAI designated and an AIGRS, and a CCIM. I've done numerous of these types of studies. I've been before this board, Superior Court, other different places. And I was trying to think what else you want me to tell you.
Did you prepare an affidavit as well as a report as an attachment to that affidavit for this board?
I did.
And is Exhibit 7, is that a copy of your affidavit with report?
Yes, excuse me, yes, it is.
Mr. Chairman, I'd like to offer Exhibit 7 into the record, and is that okay?
Yes.
And this has also been uploaded as well, that you should have access to.
And you're tendering your witness as an expert?
That's right, in property value impact analysis.
Any concerns? So tendered and accepted. Thank you.
Thank you.
All right, John, well, walk them through what your findings and conclusions were relating to the project.
What I did for this project was I got a set of the plans and other information from the client and looked at the property, did some investigations, did an extensive search for similar type townhouse, townhome properties. And out of that data set, I ended up with 5 that I thought were most applicable. Then we started looking for, basically I do it by sales, resales over a period of years to see if there's an impact based on a project going in under certain days, before and after is what we call it. After I did that, I compiled everything and I came to a conclusion.
And what was your conclusion?
It would have no detrimental effect on public welfare or injurious to the property or public improvements in the neighborhood of the proposed special use permit.
Okay, and specific to property values, what is your conclusion about the impact on property value?
There was no definitive one way or the other whether it would have an impact on the property values.
Okay. And in terms of your affidavit, I think your opinions are contained within the first page of your affidavit, is that right?
Yes.
Okay. That's the questions I have for John.
No, I don't hear any questions.
Yeah, I just want to make sure I understood what you said. It sounded to me like you said, and if this isn't what you said, I want you to correct it,
Yes, sir.
that you didn't know one way or another if it would affect property values.
No, that's not exactly what I said. What I said was I couldn't find any evidence that there would be a detrimental effect on the properties themselves, nor could I find any kind of a effect of whether it would be increasing. It would be
It was a matter of evidence.
There's not enough evidence, no.
Oh, okay, thank you.
Sorry.
Quickly, Joel? Yep.
Some of the other properties that you looked at, what similarities did they share with this proposed development?
As far as the property type,
Yeah.
they were all townhomes, townhouses. There was some mixed use. I think it was one mixed use that I looked at. So they were similar in style, similar in property use.
And in terms of density?
Density was on the lower end of the spectrum. On page 22 of the report, if you've got that, is a table which takes into account the comparables I used. Also has some other information on other ones that we considered, and they range from about 4 units per acre up to about 14 and a half units per acre. So this is 6.52, I believe.
So just, and for those who are not looking at the page, in terms of that particular table, the project density that's proposed is 6.51. In all the comparables you looked at for townhome developments, the densities are higher.
Or higher.
All right, hearing no other questions, thank you very much.
Certainly. Thank you.
And we offer, again, if there was a witness or anybody that wanted to ask a question.
I did not hear that they had posed a question regarding, was there one? Okay, just prolonging, we're having trial within a trial here, Counselor.
I'm sorry, I'm just trying to be nice.
I've learned my lesson, not to do this. Yes, sir, question, you have a question regarding the testimony by this expert witness in real estate value. Please come forward.
Swear me in again?
No.
Okay. So, picture this. I have this 30 feet wide screen porch, and now it's looking out basically over a meadow with 100-foot tall trees, panoramic view, and then beyond it, and in the winter, there's a farm with, I don't know, farm fields and, just more trees off in the distance. And now instead there's going to be a retaining wall and a whole bunch of skinny, tall houses. And that's not going to affect my property value?
Specifically, I can't answer that question because I didn't do an appraisal on your property. This is in general as far as what the effect would be for the whole project.
Well, that was my reason for requesting status. All right.
But in terms of the, I think your findings and conclusion is that when you looked at higher density townhouse developments, you did not find evidence of a detrimental impact.
No.
I think we're done. Thank you.
Yes.
Thank you.
Our last witness, other than the property owner representative is here, is Jeff Moore.
Good afternoon, Mr. Chair, and members of the board,
Hi.
and county staff.
Please raise your right hand and state your name.
Jeffrey H. Moore.
Do you swear or affirm to tell the truth at this hearing?
Yes, I do.
All right, Jeffrey, why don't you go ahead and introduce yourself, mention your qualifications and your relationship to the project.
Thank you, sir. Yes, I'm Jeff Moore. I'm a professional engineer in the state of North Carolina, South Carolina, Georgia, and Florida. I was, my bachelor's degree is from Clemson University in civil engineering. I also have a little training in Air Force combat civil engineering, which I hope I don't need here today. Part of my experience, I'm a highway maintenance / traffic engineer with about 25 years of experience in the engineering part. Also, I'm a subject matter expert with NCEES, that is the National Council of Examiners for Engineers and Surveyors, where I get to help participate working on the professional engineer exam.
And you have testified before this board before?
Yes, sir, I have, and I also have experience serving on my hometown's Board of Adjustments, and then I had to give that up when I got elected to town council.
Have you prepared an affidavit with a report of your findings and conclusions relating to traffic, potential traffic impacts?
Yes, sir, I have.
And I'll mark it as Exhibit 8. Is that a copy of your affidavit with your report?
Yes, sir, that is.
And Mr. Chairman, I'd like to introduce Exhibit 8 into the record.
Accepted.
Exhibit 8, that includes your resume. Is that correct? Jeff?
Yes, sir, it does.
Mr. Chairman, I'd like to tender this witness as an expert in traffic engineering.
Hearing no questions, so accepted.
All right, Jeff, if you would, explain to the board what your findings and conclusions were related to the project.
Yes, sir, and if the board will indulge me, I'll try to make it quick, but I'd like to talk a little bit about the traffic study itself and how we got to the conclusions that we got to, and a little bit of the process. We started out when our client retained us to determine which particular land use to use and determine if a traffic impact analysis were going to be necessary. So based on the type development, we determined it was land use 215, and that's from the Institute of Transportation Engineers Trip Generation Manual. That is single-family attached housing. And the definition of that, and I'll skip through this, but the important part is that a single structure with 3 or more distinct dwelling units joined side by side in a row, each with an outside entrance. So that's how we determined Land Use Code 215. That was confirmed by the NCDOT as part of the scoping process. Once we determined the type land use, we also looked at the density. The NCDOT requires a TIA if the daily trip number is greater than 3,000. However, the Buncombe County zoning ordinance requires a TIA if there are more than 75 units. So therefore, a TIA was required. We went through the scoping process. Once a TIA is required by a municipality or a county, NCDOT then takes jurisdiction over the scoping process and the review process. So we went through the scoping process. We did the trip generation. We found that, and we did the trip generation for 208 units. That's what the TIA says. However, what's being proposed is a lower number, so we're a little bit more conservative in our findings. And it's not uncommon that densities change throughout a process, throughout the process. So as part of the scoping, we submitted our trip generation. We also submitted our trip distribution and how those trips are going to flow out into the neighboring, into the community and the transportation infrastructure. Another part of that was the background growth rate so that we could determine what future conditions are going to be. That was also in conjunction with the NCDOT. That was approved by them as part of the scoping. We looked at 4 intersections to determine the impacts on those particular intersections. Those were also approved by NCDOT, and we went through that process. Then we, the DOT approved our scoping. We moved forward with the TIA. We did traffic counts, turning movement counts. Those were done at AM and PM peak hours on typical days, which would be a Tuesday, Wednesday, Thursday, with school in session, to grab, a snapshot of what's going on out there. Then those numbers were used to go into the traffic modeling to determine levels of service. We did levels of service for the existing conditions, background conditions, which also typically include other developments that are being built and approved. In this case, NCDOT tells us what to use. We're very highly regulated by NCDOT, if you haven't figured that out. And based on that, there were no adjacent developments that we were told to use, so we used the background growth rate. Again, that was determined by DOT. That was submitted to NCDOT once the traffic study was done. That was looked at for completeness to determine if we'd hit all of the congestion management guidelines. They had a few comments. We addressed the comments, sent that back, and then they made the final decision, which was that the TIA was accepted by NCDOT, and the mitigations that we suggested are then made formal through the NCDOT final decision letter. So we do have that certification by DOT that they have accepted our TIA. I'd be happy to answer any questions or
Yeah, why don't you
elaborate.
explain to the board what the traffic mitigation measure was that you had recommended that the DOT agreed with?
All right, sir. The mitigation that we recommended and it's on the, let me find it. The intersections that we studied are all operating at an acceptable level of service, so there were no mitigations required there. And what was required, and I apologize, I should have had, I can never find things when I look up here. To widen the existing travel lanes in the area in the frontage of the project to 12 feet to meet the minimum NCDOT requirement for their lane width. So there were no mitigations required at any of the intersections we studied, and the driveway design that's shown on the site plan is what they accepted.
And the sheet that you're looking at, if anybody wants to look at the sheet, does it have a number?
It is in the TIA, and it's also in the NCDOT final decision letter, which is submitted.
And in terms of the driveway, the driveways that are proposed, in terms
sir.
of whether they present satisfactory ingress and egress, you looked at that, correct?
Yes, sir, we did. We also looked at the site distance at those to see if they met the requirements, typically 100 feet of site distance per 10 miles per hour, 35 miles per hour. From what we can conclude, it meets the site distance requirements.
And from your affidavit, it indicates that based on your experience as a traffic engineer and your knowledge of the project, that this project complies with all the traffic-related standards of the Buncombe County Special Use requirements, right?
Yes, sir, that's correct.
Those are the questions I have, Mr. Chairman.
Thank you. Yes, Mark?
There's one line in this report. It says, "It should be noted that poor line of sight and excessive queuing may persist throughout network after recommended developer and outside mitigation." Could you elaborate on that a little bit?
There are some intersections that currently have some issues that are noted in the TIA. Our requirement is to not make it substantially worse. You add one car, you add 25 feet of queuing. The requirement that we have is not to significantly make it worse. And also, is that intersection operating at capacity or is it over capacity? That's level of service F. We all know what that is. In this case, we didn't have any of those, thankfully. But anytime you add a number of vehicles, it's going to add. It's going to add a little delay. It's going to add some queuing. I don't know if that helps with that. The main thing that we are held to is, are we making it worse, as in, are we dropping a level of service or are we making an F worse? So in this case, and that's also reflected if the DOT requires mitigation. And we also have to point it out, even if it's something that we didn't cause. So does that help? Thank you, sir.
And it's important to understand, all these intersections and the roads in question, these are all DOT-controlled, owned roads, correct?
They are, yes, sir.
Any other questions? Thank you.
Thank you, sir.
I'm going to, for the sake of keeping us on task, this is a good point. I believe there was one gentleman who had a traffic question who was a witness who came forward earlier. Was your question answered? Ma'am, I'm sorry.
That's a new person.
Yeah, that's a new person. I'm staying with the original four. Yes, sir.
I do have a couple questions.
Come forward.
So in the traffic study, and once again, this is a learning process for me, there's a category called trip generation.
Yes, sir, that's correct.
And this is showing daily trips, 1,534.
Yes, sir, that's correct.
Is that the incremental trips due to this development?
That's a great question. Yes, sir. And typically, with a single family attached, we see 7 trips per day per unit. And that's a rule of thumb. We use the ITE trip generation manual, which DOT tells us whether to use the rate, which is an average rate, or an equation, which typically involves logarithms. In this case, we use the equation. We also use the traffic based on a peak hour. So the daily trips will be 1,534 trips per day. That's spread out over 24 hours. But what we're more concerned with is the peak hour. And that's a period from 7 to 9 a.m. or 4 to 6 p.m. Now, if there was a school immediately adjacent, we would also look at that school traffic, which is, 2 to 4 p.m. In this case, we didn't do that, didn't need to do that. So it is 1,534 trips per day, but the AM peak hour would be 102, and that's, and there's also some averaging here. So there's 26 entering, 78 exiting, and then the PM peak hour would be 71 entering and 50 exiting for 121 in the PM peak hour. And that breaks down to about 1 every 2 minutes entering in the morning, which makes sense because people are going out in the morning mostly. And then in the afternoon, it would be 78, which is a little over 1 per minute exiting. And then those are distributed out through the network. Some turn left, some turn right, some go here, turn left, turn right. And that's all the percentages that we submit to DOT for approval.
And so, so was an analysis done that this incremental increase added on to the current traffic load?
Yes, sir.
Has that met whatever existing standard there is?
Yes, sir, and it's not just the existing. What we do is we grow the existing traffic by the observed growth rate. In this case, and that determines the background traffic. So what we are constrained to do is determine the impacts of the added site traffic versus the background traffic. So that's how we came up with that.
Okay. And just one other thing, I know you mentioned DOT didn't have you take into account any current development going on, I think is what you said, any additional?
They tell us what to look at.
Okay.
And they had us just use the background growth rate.
Well, there is a current development going on 1/4 of a mile from the intersection of Ledbetter and Glenbridge Road. So I just find it surprising that they would not have that included.
Yes, sir. We are very, very regulated and directed by what DOT has us do. And in this case, the background traffic growth is what they directed us to use.
Okay. All right. Thank you.
And Jeff, the communications with the DOT where they approved the scoping and walking through this journey, they're all included in your affidavit, right?
Yes, sir, they are.
Yeah. And for single-family attached, that's a 7-trip generation that you mentioned. What is single-family detached?
It's about 10.
So single-family detached is actually a projected higher trip generation than what this project is.
Yes, sir, it's about 10.
And did you hear the witness earlier say that in terms of the density that EMP allows, that a single-family detached subdivision could occur?
Yes, sir.
That would actually be generating more traffic than what is being proposed by this
If I
development.
believe with more density as well, more units.
Yeah.
Okay. Thank you.
Thank you.
Thank you.
Thank you, Jeff.
Any additional witness?
So
Mr.
we do
Duffy?
have owner representatives here that are available if you have any questions, but those are our witnesses.
One moment. Any other questions for Mr. Justice or desire to have the owners come forth and answer any unanswered questions? All right. Yes, now it is the time where we hear the witnesses who have come to provide their input to the process. So do we have any folks who had previously identified themselves as being witnesses? And let me clarify, of the 4 who originally went through the process to ask for standing, have your questions been answered to the point where you don't need to pose additional questions? Yes, yes, yes. Yeah, we will add. I'm just asking whether the 4 who originally had come forward, whether they have now felt they've had their opportunity to ask questions or to present their information as a witness. Anyone else who had previously requested as a witness?
Yeah, just 2. There's Glass and Hazlitt.
Glass and
Hazlitt.
Haslin.
Mhm.
Then we have both Glass and Haslin here. Choose who comes forward and be sworn in. Thank you.
Please state your name and raise your right hand.
Ma'am?
Sheila Glass.
Okay. Do you swear or affirm to tell the truth during this hearing?
Yes.
And if I could just remind you to please speak into the mic. Thank you.
Right, so my name is Sheila Glass, and
Welcome. Welcome.
thank you. I live on the community, on the, I'm not sure what my directions, because I just moved here 4 years ago. But my community is called Mallard Run. And we currently have 78 detached homes. And I live at the very, very bottom of Mallard Run Drive. And I had moved over from the other part of the country, Las Vegas, Nevada. And when I discovered this beautiful real estate, I was very excited, and I really wanted to be part of the community so I could enjoy the beautiful scenery. And about 2 years ago, they decided to, they were going to tear out all of these beautiful old growth trees, a big meadow, a lot of the trees along the little creek. And I don't know the name of the creek. I think it's Avery Creek. I'm not exactly sure which one it is. But anyway, before they started to do the land part where they smooth out the land so that and build up the land, they sent a man to all of our homes that were overlooking the area that they were going to add 28 new homes. And so to refer to Ms. Martin's comment about the noise and the booming, they had to use a lot of dynamite, and there was a lot of shaking and a lot of booming going on, just to make the land susceptible for these new homes. This has been 2 years ago, and these people aren't even halfway through building all the next 28 homes. So we have a lot of traffic, earth-moving traffic, construction traffic, going through our solitary little Mallard Run Drive road. And it's slowed down a little, but what I'm trying to tell you is that the traffic that's out on Glenbridge Road and Ledbetter Road, those roads are already filled with construction vehicles and huge trucks. Now, I did notice when I was driving here that they did something to Ledbetter Road. They repaved it. It seems to be wider. But the Glenbridge Road going out towards the mulch yard, there's big ditches on each side. There's nothing really, any kind of a side place for anybody to walk on or a car to drive for a car to drive on to. And there's one. I remember the road just stops and then it just goes down, and it's like this much. It would totally, tear out the bottom of your car. So I'm just wondering, how are they going to improve the road infrastructure for all of these new people coming in? And yes, not only that new construction of that's a quarter mile down Ledbetter Road, not only is that something that we have to consider, we also have to consider Hollow Crest Way, Briar Creek Way, Hadley Park Way. These people are all using our roads. Now, I'm a substitute teacher, and I have to get up early and get to, I go to all these schools. I go to Reynolds. I go to Irwin, T.C. Roberson.
Ma'am, if I can interject, just as I had said earlier at the beginning of the meeting, we have to take into account the expert witnesses that come forward, and we have had an expert witness who has addressed a number of the traffic potential scenarios.
Yes, but I'm trying to express my personal experiences.
Correct,
And he hasn't mentioned that. He hasn't mentioned the car backup on Ledbetter Road in the morning. It goes back a quarter to a half a mile back. We're just sitting there. And I'm beside myself. I have to completely turn my car around because I don't want to spend another hour waiting to get on to Long Shoals Road.
So, Mr. Chairman, I was trying to be, I guess, a little courteous, maybe overly courteous. To the extent the witness is encroaching into the area of saying there are problems, hazards, undue congestion, undue things, these are all questions for the traffic engineer.
Yeah.
We have gone through the process with the owner of the road, which is the DOT, and they have reached their conclusions. So I understand a lot of people will have their own personal opinions, but respectfully, you do seem to be encroaching into an area that does require an expert.
Yeah, I mean, well, after
understand.
listening, I wanted to express my personal experiences. To me, well, the roads are too narrow to handle all of those huge trucks and the earth-moving equipment that they have. There's no sidewalks, and they are just now, just at the beginning of this year, raising those questions about putting sidewalks in. So there's children that would
Ma'am,
like to.
again, we're confined, this board, by the building ordinances and the zoning requirements for the county.
Okay.
Many of the things that you're bringing up are of a concern of the citizens of Buncombe County, and I share those. But recognize that, as Mr. Justice has said, the state of North Carolina owns the roads and controls the roads and dictates when and how the roads need to be expanded. And sidewalks. That is not something within the purview of this board to dictate that there'll be sidewalks placed into communities unless the ordinance requires it. So we're sympathetic with your concerns, but yet they fall outside of the jurisdiction of this board.
Will I be able to express my concerns at another meeting?
There will be, as we have the owner representative here, and there can be continuing dialogue that people should reach out to our client.
Specific to the development.
Specific to the development.
Right. I would say beyond the development to the overall infrastructure, you need to look to your elected officials and determine whether there's any course of action that they wish to pursue to address it.
Elected officials such as who would that I have?
County commissioners
Right here?
and the state government for the Department of Transportation.
Okay. All right. Okay, so,
So for the sake of time, and we have one other witness who would like to come and speak, is there any? Okay, thank you.
thank you.
Please state your name and raise your right hand.
Amy Haslett?
Do you swear or affirm to tell the truth at this hearing?
Yes. Thank you. All right. So I wanted to discuss three concerns that I have. All of them are about traffic. So figure 7 in the traffic impact analysis, that shows the earliest data points where they have all the high traffic. And that shows that 8 a.m. to 9 a.m. was selected as the morning peak hour. Avery Creek Elementary School sits just beyond the 5-point intersection at North Carolina 191 and Gledbridge Road, which is the intersection 1. The school day starts at 7:15, so I just don't understand how that's not part of the peak hours. How is the peak hours from 8 to 9 when there's school drop-off from 7:15 to 7:50? And through discussions with the neighborhood, I have 2 young kids. They're not in elementary school yet, but if you leave the house, it takes 15 to 20 minutes to get to school. And that's if you leave at 7:15. That's crazy. And then one neighbor, if they left at 7:25, they don't get to school till 7:50. So it's just how is the peak from 8 to 9? The time when most kids are on the road is earlier than that. How is that not the peak? It just doesn't make sense. And then the afternoon pickup is at 2:30, and there's no time for the peak pickup time. And the school is 1 mile away from that intersection. It just makes no sense, and it just makes me so nervous about having my kids in that car. There's already been 25 accidents at that intersection, one of them severe. And that intersection, it's operating at a level E. A service E. So no, we didn't drop to an F, but it's still an E. It's terrible. That intersection is so terrible. You just sit there and you sit there and you sit there. And once again, I know I'm not an expert witness. However, I am a very concerned mother. I just don't see how we're going to stay in the area. I just do not understand how that was not part of the peak time, how that is not considered. Yeah, and then the other thing that made me nervous too is I'm also in the Mallard Run community, and I know earlier it was stated that you need 350 feet of visibility either way. Right now, there's no way that we have that. And also in the report with this entrance point A and B, they said it appears to have 350 feet. They did not measure it. So that right there makes me anxious. But also, we definitely don't have 350 feet, and we have a sign that says, watch out for the traffic. No one listens to that at all. So it's and the other thing too is there's roughly going to be, they said 1,500 trips on that road now. Right now, as it stands, there's only 3,300 trips on that road total. So you're adding 50% to the road in front of our house that already has a blind curve. That already, it's constantly the community is talking about, man, we really need a mirror. And we said that before this was going to happen. It's just, how are we adding 50% volume to a road? And that's not considered. So I think, once again, I'm not a witness. I do not pretend to be. However, I really would like to understand why 8 to 9 was the peak window when I know for a fact it is backed up before that with school drop-off. And that's when your kids are on the road. Those are the people who we're supposed to protect them. We're supposed to protect our kids. And I don't see how we're doing that with this.
So all I can say is, the DOT almost sets the test, right? So they do the scoping, they do all the things of, this is what you're supposed to look at in terms of peak hours. You can go out there and measure count the cars, right? So they tell us everything to do. And so these are really more fundamental questions of the DOT process, because what can a developer do but the owner of the road says, do it this way. And so we have done it that way, and at the end of the day, they've approved our plan with the mitigation that is shown. And I will just reiterate again, the density that we're proposing in terms of what the county ordinance would have otherwise allowed is about half.
But there's a school 1 mile away from the intersection, and that was nowhere in the report. That's crazy.
Mr. Chairman, I could I don't want to debate this witness. That's what I would like to offer.
No questions, Joel? No. Thank you very much. Any other witnesses present?
I had the statement from the other person who was going to request status, but I can't read it, right?
No, sir. I'm sorry. No, sir. All right, we'll close. Any closing comments?
My only closing is that we have a law, that rule of law is awfully important and that we follow. And it requires in this context that, we show that we meet all the ordinance standards. And there's a lot of people that have hopes and then wishes and desires. And a lot of that is already answered by the elected officials when they establish what the law is and the parameters of what is expected of developers of new property. And so we have met those standards with the witnesses that the law requires, which are our expert witnesses, and you have no counter expert witnesses. And so all due respect to the concerns, we respect them, but we do believe we've met the standards for a special use permit. Thank you.
All right. At this point, we'll close the public hearing. No more questions of the witnesses or the applicant. And now we're in discussion among board members about your feelings of this particular application.
Excuse me,
Joel, you
Mr.
got your
Vice
hand
Chair.
up.
I feel this is probably the appropriate place to do this. Correct me if I'm wrong, but in light of the conversations that we've been having here, Buncombe County would like to propose 2 additional conditions on this. The first is just clarifying the subdivision and lack thereof. We would like to add the condition that the applicant has indicated that no subdivision will occur on this property. The property does not meet the standards of the Buncombe County Land Development and Subdivision Ordinance. If a subdivision is proposed in the future, a revised special use permit shall be required, and a new subdivision application meeting the requirements of the Land Development and Subdivision Ordinance would have to be submitted and approved in order for subdivision to occur in this development.
So if we had wanted to come in with lots, and I've done that before with the Brevard Road project, I came before y'all probably three or 4 months ago. We understand we have to submit a new application and come before this body. So I'm not sure why that is required as a condition. We understand that to be the case, but that's my only comment to that.
Okay. Are there any objections then to the condition?
If we want to create lots and sell, we understand we've got to come back before you. But do you have a problem with that? No, we don't have a problem.
Okay. Second condition is the applicant shall install a 20-foot landscape buffer consisting of 2 rows of evergreen trees at least 5 feet in height at the northwest property line and the eastern property line as shown on the submitted landscape site rendering.
Yes, that was what we had offered to do. Yep. And of course, there is going to be, to your question, there's got to be a little bit of let the professionals do their job in terms of figuring out what will kill an existing tree, but we will substantially comply with what is represented here in the field, sure.
Substantially apply or will apply?
Well,
Who's going to be the judge of substantial?
it is, they look at it from the standpoint, have we done enough? But at the end of the day, that plan is a representation, and as long as as we all understand, that when you put a plan you got to then go out in the field and make sure it makes sense exactly where you place it. So in terms of scale and all that, there has to be some reason, and that's why I'm just saying that, that in terms of exactly that plan at that location, there has to be some reason. But I would say just attach it as a condition, and we'll figure that out as we go through it, yes.
So we're in board discussion, subject to Jason's adding of the clarification.
Question regarding what was just discussed.
Yes?
Okay, in that condition there, was there any mention about dealing with the buffers and so forth as a good faith discussion with the surrounding landowners? And is that legal to put into a condition?
Well,
We is not the issue. I mean, you can put pretty much conditions as you see fit into these orders. I mean, this, to be fair to Mr. Justice, I mean, this isn't a negotiation. If this board decides to put that in, the applicant will have to comply with it. In terms of discussions with other landowners, I don't have any information to that effect.
But Joel, I think to the point, if you believe that that's a condition, now's the time to raise it here, and as the board, we'll make a determination of whether your condition is something that we should go forward with.
Okay, yeah, I would like to see that as a condition, that in good faith, the developer or his representatives discuss with the neighbors to try to alleviate concerns. I mean, I've seen the history of this board. Even as cases come up, they continue with discussions with the neighbors to try to alleviate the situation.
So I think, just to bring a little clarification here, what I understand it to be is the 20-foot undisturbed area as being discussed. What it is that there's a combination here of the buffer being the landscape buffer, which has different county requirements, which I think is what Jason was pointing out, to make sure that those are met. And then the undisturbed area is also being met, which means it's got to be surveyed, it's got to have all the trees, circumferences and rings and all those that go into the calculation so that you get the best of both worlds. You get the trees that exist that are there, so they're not disturbing 20 feet of it, and then they're going to be supplementing that as well. And I think that's part of what they're going to have a landscape professional go in there and make sure it gets installed that meets what the county is requesting.
Do you feel comfortable now, Joel, with what conditions Jason has put forth for the applicant?
Yeah, I'm making an assumption as far as any conditions agreed to, let's say, with the developer and neighbors, you know, they're going to be involved with professionals, because some things may not be feasible. I mean, that's why you have discussions to determine that. And, you know, I'm not an expert in trees, buffers, things like that. So, I mean, if you want to add the word based on discussion with experts, I have no problem with that, rather than make that assumption.
You're good with that?
So I just want to understand the language of the condition. The plan, we agreed to the language that Jason had. Joe, there will be, as I've said, there will be opportunities for additional discussions. The problem, Joel, of saying good faith and discussions is you might have a neighbor that says, well, you didn't discuss enough with me, so, hey, county, stop this project. And it'd be a question of how do you enforce that? I can just say that our folks are available to have further discussions. To make a condition seems to kind of vague and how hard to enforce. And I'd hate the project to stop because some neighbor said, hey, you missed me.
All right. Jason, you introduced us with this. Where do you think we are in terms of this condition? You started it.
The point of the condition is, you know, based upon the buffering concerns that were brought up, and this was a buffering plan that was submitted as part of the application packet. One of the boilerplate conditions is that the project must be constructed as depicted in the site plan. But sometimes we like to just specifically point out things just to put on record specifically. We do not believe this condition contradicts anything like that. This is what was proposed. So as long as that minimum would be met, then the county has no issue with that. But when it comes to a third party being involved or conversing with a third party, there's really no enforcement that we can do on that. The county doesn't have any jurisdiction on mitigating between two parties for civil issues. Now, that certainly happens in other projects where the developer speaks with other property owners, and then things change or become, and that certainly happens, but that's not something that the county can enforce.
All right. Any other questions on this? All right. Back to group dialogue. Thoughts on the application with the conditions that have been noted?
I think they've met the requirements of the SUP as presented.
The one drain pipe that you brought up is actually on the set of plans, so it is there.
And I believe they're expanding and widening the road in front of the complex, as originally noted, as a concern of being narrowed.
I do like the developer utilizing the rear to get the three-story back there just because of the topography situation, so that looks nice.
Up against the Avery Creek, near the Avery Creek property, correct? The setbacks are well in excess of what they're required to have. The density is less than what it could have potentially have been.
And I trust that the developer is going to take care of the buffers, the best effort possible.
Yeah, the Buncombe County the buffer and landscape ordinance is pretty clear for them to follow and scrutinize as they go through the final permitting process.
All right. Any concluding thoughts? Greg? Anyone interested in bringing forth a motion?
Mr. Chair, based upon the evidence presented to this board, including the following exhibits, petitioner's application, the submitted development plan, the GIS maps, staff report, testimony presented at the hearing, I move that this board adopt the following findings of fact. This matter was properly advertised, is within the board's jurisdiction, and is right for its consideration. That this application, together with the conditions proposed by staff and/or this board and agreed to by the applicant, does meet the requirements for granting a special use permit contained in Buncombe County Code of Ordinances, Section 78-621, Paragraph 3.
Second.
We have a motion and we have a second. All in favor, say aye.
Aye.
Those opposed, nay.
Mr. Chair, based upon the foregoing findings of fact and for the reasons set forth therein, I move that the requested special use be approved and that the order approving the permit be adopted and executed as presented and as modified in this meeting.
Second.
All in favor, aye.
Aye.
Those opposed? That passes. Amy, ready for the order?
Sure. Dispensing with the caption, having considered the evidence presented to this board, including the application, the submitted development plans, the GIS maps, the staff report, the applicant's affidavits, the testimony presented, and the arguments advanced by the parties, the board hereby finds as follows. 1, this matter was properly noticed and advertised, is within the board's jurisdiction, and is ripe for its consideration. The applicant applied for a special use permit pursuant to the zoning ordinance of Buncombe County to establish a planned unit development level 1 for 191 residential development. The property is located in an employment zoning district. At the hearing, the applicant and any parties withstanding were given the opportunity to offer oral and documentary evidence, as well as to submit questions to each other, county staff, and board members. That pursuant to the Buncombe County Code of Ordinances, the board finds as follows regarding the special use proposed in the application. With respect to the PUD 1 standards, 1, that the land lies within a PUD, the land lies within the PUD will be under single ownership or management by the applicant before final approval or construction or proper assurances have been provided such that the development can be successfully completed by the applicant. 2, the density is consistent with the intent of the district in which it is located and conforms to that permitted in the district in which the development is located. 3, that the land uses are compatible with and do not violate the intent of the zoning district and do not disrupt the character of the community. 4, that the proposed land use meets minimum requirements for land development as follows. 4A, the minimum lot size and requirements for interior setbacks do preserve the spirit and intent of this section and comply with the density requirements for the zoning district with respect for the total development planned. 4B, proposed heights as set forth in the application comply with the spirit and intent of this section with respect to the total development plan. Where building heights exceed the maximum allowed by the ordinance, this board finds that unique elements of the development impose requirements for additional height that are not universal throughout the zoning district. 4C, this board finds that the minimum distance between buildings will ensure adequate air, light, privacy, and space for emergency vehicles. 5, that the development does provide reasonable visual and acoustical privacy for all dwelling units. Fences, insulation, walks, barriers, and landscaping will be used for the protection and aesthetic enhancement of the property and privacy of its occupants, screening of objectionable views or uses, and reduction of noise. Multi-level buildings are located in such a way as to dissipate any adverse impact on adjoining low-rise buildings and do not invade the privacy of the occupants of such low-rise buildings. 6, that the structures located on the perimeter of the development will be set back from property lines and rights-of-way abutting streets in accordance with the provisions of the zoning ordinance controlling the district. 7, this board finds that proposed parking complies with the spirit and intent of the section. 8, as applicable, this board finds that the conveyance and maintenance of open space, recreational areas, and communally owned facilities are in accordance with the general statutes, 47-1, the Unit Ownership Act, and or any other appropriate mechanisms. 9, this board finds that the building envelopes are shown in the submitted plans and depict the maximum expanse of the proposed footprint of the structures. Pursuant to Section 78-677G of the Buncombe County zoning ordinance, satisfactory provision and arrangements have been made for the following. The use will not adversely affect the health or safety of persons residing or working in the neighborhood. The proposed use will not be detrimental to public welfare or injurious to property or public improvements. The proposed use will not cause or have adverse effects on surrounding properties due to noise, vibration, odor, or glare effects. 4, satisfactory ingress and egress for the use of the property and proposed structure have been provided. Particular attention has been paid to the automotive and pedestrian safety and convenience, traffic flow, and control. 5, provision of off-street parking and loading areas where required, with particular attention to Section 78-658 of the Buncombe County zoning ordinance have been arranged for. Provisions for adequate and proper utilities with reference to locations, availability, and compatibility have been arranged for. Provision of buffering, if deemed necessary, with reference to type, location, and dimensions has been arranged for. Signs, if any, and proposed exterior lighting with reference to glare, traffic safety, economic effect, and compatibility are in harmony with properties in the district. Playgrounds, open spaces, yards, landscaping, access ways, and pedestrian ways with reference to location, size, and suitability have been arranged for. Buildings and structures with reference to location, size, and use are acceptable. Hours of operation with particular reference to protecting and maintaining the character of the neighborhood are acceptable. The following conditions are necessary to ensure the proposed use will conform to the requirements and spirit of the Buncombe County zoning ordinance. In addition to the standard conditions, the following four conditions. 1, a recombination of the pins listed in this order must take place and a new pin assigned prior to submitting a site plan application. 2, an NCDOT permit is required. 3, the applicant shall install a 20-foot landscape buffer consisting of 2 rows of evergreen trees at least 5 feet in height at the northwest property line and the eastern property line as shown on the submitted landscape rendering. 4, the applicant has indicated that no subdivision will occur on this property. Property does not meet the standards of the Buncombe County Land Development and Subdivision Ordinance. If a subdivision is proposed in the future, a revised special use permit shall be required, and a new subdivision application meeting the requirements of the Land Development and Subdivision Ordinance would have to be submitted and approved in order for the subdivision to occur in this development. Master site plan permit approval shall not replace the requirement of pulling an individual site plan permit for each building or structure within the development. Based on the foregoing findings of fact, the board makes the following conclusions of law. The applicant's request for a special use permit, together with the imposition of the conditions found necessary above, which are incorporated herein as if fully set forth, meets each applicable requirement of the Buncombe County zoning ordinance. Now, therefore, based on the foregoing findings of fact and conclusions of law, the Buncombe County Board of Adjustment orders as follows. The applicant is hereby granted a special use permit to establish a planned unit development on the property as requested, subject to the conditions referenced above, which are incorporated herein as if fully set forth. August 12th, 2026.
Thank you, Amy. Order's been put forth. Is there a motion?
Can I ask for one point of clarification, Amy?
Sure.
Should there be a line that says that the 3 persons applying for standing failed to demonstrate special damages as required by state statute, just so that the order does encapsulate the determination, or is that, you don't do that?
I don't know
We
that we've
typically
ever
don't do
done.
that, but that's up to the board if they want me
I
to.
don't know
include
that we've ever done that.
Okay. I've just seen it
And
in
you've already-
most jurisdictions that there is an order that reflects about it, but if you don't do it, then I'm not going to sit here and
No.
rock that.
I mean, I guess I would ask the obvious question, what, well, or I would guess, why not? Amy, do you have thoughts on that?
Or are we setting a precedent?
It could be a finding of fact. It doesn't really bear one way or the other since the findings were in the negative for each of the applicants.
And that is in the record?
That is in the record.
It is in the record.
Okay.
Yeah, what would be that exact, I didn't hear, what would be that exact condition again?
We're not talking about conditions. Mr. Justice is requesting.
Yeah.
There should be a finding of fact that 3 individuals requested standing and that the board found in the negative for each of those individuals.
Oh, okay,
But
we
it is-
usually don't do that. Can I ask your reasoning?
It's
Or-
an order of a determination, but again, I'm not rocking the boat. I just wanted to ask the question if it was easily inserted, and if it's not, I'm not going to sit here and rock the boat about it. But I've seen it in most jurisdictions where it was included, but it's fine.
Yeah, because I hate to see it. I can't remember ever doing that. And I hate to see it. I think it's assumption
We're on
since
the
it's
same page.
record.
We're on the same page. It's part of the record. So it's already there. So back to, do we have a motion on the order?
Motion to approve the order?
Second?
All in favor, say aye.
Aye.
Any opposed? That motion passes, and order is issued.
Yes, please.
Okay, 5 minutes. Hold it to 5. They get through one more, I think. You have the 35 minutes. Thank you. Bree, you have the 35 minutes. So is the applicant in agreement if a motion were brought forward to continue that case? Or we can have you sit and see if we get through this other case and start with your case.
No, thank you for that. We'd prefer to save the time, and we'll see you next month.
All right.
And we'll work on where we are on the agenda.
All right. Need a
Thank you.
motion for that, I believe. Anybody want to put forth a motion quickly?
Motion to move it to next.
Second? Agreed? All say aye?
Aye.
All right, thank you. Then let's move on to the Cogdill Variance. Again, that is 00025. And looks like Griffin is our spokesperson that gives us a briefing on this one.
Good afternoon again. I certify that this public hearing was properly noticed and that all applicable parties were notified of the meeting in accordance with general statutes and county code. I ask that all applicant and staff materials be accepted into the record as evidence.
Accepted.
This is a review of ZPH 2026-00025, the Cogdill Variance. The applicant is Justin Nicholas of Livingstone Design and Build on behalf of the owners, Carl and Nicole Cogdill. The subject property is located off Cliff Ledge Trail in the High Cliffs at Round Mountain subdivision. Subdivision is in southeastern Buncombe County off Highway 9 south of Black Mountain. The size of the subject property is 5.02 acres. Septic system and well are planned to service the proposed future residents on this property. The property is in the open use zoning district, with nearly the entire parcel being in the steep slope or protected ridge overlay districts. The area of the property proposed for development is entirely within the protected ridge overlay. Section 78-645F4 of the Protected Ridge Overlay Development Standards requires that building width shall not exceed 30% of the lot width as measured at the faces of the building oriented to the downhill section of the lot or adjacent topography. The applicant has requested a variance for that maximum percentage to be increased to 48.5% for construction of a single-family dwelling on this lot. This would allow a building width of 105.4 feet on a section of the lot that is 216.9 feet wide. Happy to answer any questions about this application.
Hearing none. Thank you, Jason. Or Griffin.
Okay.
I see noted we had 2 requests for standing.
Yes, we have Stinson and Gillespie.
Are they present?
I'm not sure.
Then I believe they have lost the right to bring forth their request for standing. Correct, Amy? Yes. Okay. Anyone else present requesting standing? Hearing, seeing none. Will the applicant come forward and present their case?
I think I've seen this happen enough.
Right hand and state your name.
Justin Nicholas.
Do you swear or affirm to tell the truth at this hearing?
I do. All right.
Welcome, Justin.
Well, thank you, and thank you all for having us. I'm glad we were able to get this done, or hopefully able to get this done today. So my name's Justin. I work for the builder in this case. Just for reference, since there's not a lot of us here, the owner's with us today as well. I'm Carl Cogdill, as well as we have brought Austin McKean, who was the landscape architect for this project, and I'd probably like to call on him eventually to speak to this more from a professional standpoint, as I am more of the paperwork guy and the county paperwork guy. But just the facts of the case, yeah, this is a 5-acre parcel. It is a rather long and narrow parcel. It is 1,700 feet long in the, I can't remember if it's the northwest or the north-south direction, and then the east-west is, like I think Griffith said, 216 feet at its widest, which is where the variance comes in. There is a, it's a very narrow lot to try to fit a house on. And I know for this hearing, we do not have to present that we can't have anything buildable on the lot, but we, just real quick, if the board would indulge me, we started this project probably back in December. We had consulted with Austin McKean and the architect of the house. We had put the house on the property. We'd known it was in protected ridge. There was a little bit of a discrepancy between how we believed it was going to be measured and how the county measured it. And we're not contesting how the county has it measured the property, which is why we're applying for a variance. We believe we've done everything we can on this property to make best use of it and to not be, or to be cognizant of all the protected ridge and steep slope requirements of this project. Again, I'll probably have Austin speak on more of the specifics because he knows those better than I do. But from a builder standpoint or just general questions, does the board have any that I could maybe help answer?
So for clarity, we're going to also hear additional testimony from whom?
Austin McKean, who's the one who drew the plans that were submitted.
Okay. Any questions of this witness? Yes, Joel.
I've got a question on the application.
Okay.
And this may be for staff under subsection section title says Protected Ridge Overlay District. Can you define that more for me?
To be clear, you're asking for what is the definition of the Protected Ridge Overlay District? We have that in the zoning ordinance, and I will pull it up. So I'm going to read to you two paragraphs from the zoning ordinance under the Protected Ridge Overlay District section. The first one is the purpose, and the second one is the applicability, which sort of defines the specific areas that it applies to. So the purpose is the Protected Ridge Overlay District is established in recognition that the development of land in steep mountainous areas involves special considerations and requires unique development standards. The section is intended to limit the density of development, preserve the viewshed, and protect the natural resources of Buncombe County's protected mountain ridges, consistent with the recommendations of the 1998 Buncombe County Land Use Plan and supplemental to the provisions of the Mountain Ridge Protection Act of 1983. Further, in accordance with General Statutes, Chapter 160D 703, this Protected Ridge Overlay District provides for additional requirements on properties within one or more underlying general districts related to the erection, construction, reconstruction, alteration, repair, or use of buildings or structures within the Protected Ridge Overlay District, in addition to the general underlying zoning regulations, including but not limited to height, number of stories, and size of buildings and other structures. So that is the purpose of the Protected Ridge Overlay. The next thing I'm going to go into is the applicability. So applicability, this section shall apply to all Buncombe County mountain ridges whose elevation is at least 3,000 feet and whose elevation is 500 or more feet above the elevation of an adjacent valley floor, and including 500-foot buffers measured horizontally from the center line of the ridge, as specifically identified and delineated on the zoning map, entitled the Official Zoning Map of Buncombe County, North Carolina.
So the applicant didn't ask for any modifications or changes that would violate that zoning?
The applicant is seeking a variance from one of the specific development standards that is included as a requirement within the Protected Ridge Overlay District.
Okay, thank you.
And I don't know, I know Austin has the numbers, if I could just say one more thing. I know a lot of those requirements, one is impervious area, one is the amount of disturbed area we're doing, one is house height, and one is house width as compared to the lot. The other three we are well within, it's simply the width of the residence we're building that we're asking for a variance on. We're not asking for a variance on the height of the residence or the impervious or the area of disturbance. We're well within the other parameters of protected ridge and or steep slope.
So I have one question, whether it's yours or the following witness, I'll get up now and you guys can decide. As I'm looking through for the variance, the language I'm going to read, conditions that are common to the neighborhood may not be the basis for granting a variance.
Mm-hmm.
As I look at the overview and the lots, there are others that are also restricted in a similar way.
Yes, and I guess this kind of goes back to what they were talking about earlier, to what is our, what makes ours kind of unique is ours is, and kind of substantially the skinniest lot in the neighborhood, at least as far as where the buildability is. I don't know if the board would take that into
So you're the
consideration, but the starting number we're starting with to go down to 30% of the lot width is significantly smaller. There are many lots in this neighborhood where this house, we would not have to have a variance for. We could build it as is because the lot is wide enough to build on.
How many of those lots would not allow for you to place this home that is being planned?
The one that I was for sure on, and this kind of goes into a little bit of the details of the history of this, is the adjacent lot. This lot was at one point appeared to have been split off kind of long ways down the mountain. So this lot is half as wide as similar to ours, this adjacent lot. However, when they did the lines, they drew it, and I know this because I have someone who spoke to the other builder. They drew the lines on there to be able to comply with protected ridge. So there's a little, if you notice on the GIS, the neighboring lot, so the lot to the right or to the east has a big out jut there, and that's what they used to measure for their protected ridge requirement, which ends up hurting us a little bit, but I understand that's a pre-existing condition, but it does speak a little bit to the nature of this case.
Okay.
Yeah, I'm not sure you could speak to this. I'm looking at the site map of the residence.
Mhm.
That's where you're making the zoning variance request. And I'm trying to determine what part. Is it the area that contains the patio level or the area right next to where it says approximate roof overhang?
This might be a better question for Austin. I'll try to answer it, and then I'll probably
Okay, that's
call on him
fine.
to ask. It goes from the edge of the building to the edge of the building on the downhill facing slope. Where this one got a little bit confusing, and we had some talks with the county when we found that we weren't in compliance, is because the house is not shaped like a box. It's kind of like a chevron shape, and the garage, while it faces uphill, it is part of the downhill facing plane of the house, which is, that's the part that's really the part that's tripping us up as the additional part of the variance. The house, the body of the house itself complies. It's the garage, as you're looking as the downhill face, the garage kind of chevrons off, and part of that is what is exceeding the allowable 30%.
Was this brought before the board at one time specifically?
This one has not been, no.
Okay.
If there's
Any other questions, Bart?
Well, I have a question for staff. How do we treat the information that's contained in the application for standing?
Not consider it. In order for it to be admissible, it would have to be presented by someone under oath.
Any other questions? Your next witness.
I appreciate your time. Thank you.
Good afternoon. Thank you for your time.
Ron?
Please raise your right hand and state your name.
Austin McKean.
Do you swear or affirm to tell the truth at this hearing?
I do.
Welcome, Mr. McKean.
Thank you. Yeah, I might want to start if you'll allow me to just kind of talk about a little bit of the design process on the project and a little, brief overview of the site plan itself. Is it possible can everybody see this plan, or is it possible to
Has it been?
share it on the screen?
Was it submitted as a part of the case? So we have?
Yes, I believe this was submitted, and then there were comments from one of the county planners, and then we had some email coordination regarding their comments. So I'm kind of wondering if there's a way to share the plan I'm looking at on this laptop on the screen, so we can point out some things.
Yeah, if it's the same plan that has been submitted, we have that on our
Okay.
our personal devices. That the county doesn't provide. Not anymore.
Thank you. Go to this first sheet. So yeah, as a brief overview, oh, by the way, I'll state a little bit about my background. I'm a registered landscape architect in the state of North Carolina. This is my 20th year of professional experience. I have a master's degree in landscape architecture as well from the University of Colorado. A lot of my experience was in Colorado and Wyoming doing various projects, everything from commercial development to hospital development and parks and everything in between. And so since being here for 8 years, I started I'm a sole proprietor of a landscape architecture design company called Keen Land Design. And I've been primarily doing residential work. So I've done a lot of work with Livingstone Design Build, who's here today. And so we've done a number of these types of projects, but this is the first one we've needed a variance for. But yeah, so I was brought onto this particular project in December and was coordinating closely with the architects. Starting at that point, we were aware that it was in the protected ridge overlay, so we were very cognizant about how the house would be sited based on that. So for one thing, you could see kind of on the left side where we have the section view, we worked together to basically embed the proposed house into the existing hillside. So in other words, the rear of the garage on that west side will retain some of the existing grade. And a lot of that discussion was based on, in my previous experience, the difficult requirement to meet in the protected ridge overlay is the house height. And so we wanted to have those discussions really early on to make sure we were going to meet that requirement. And by embedding it into the hillside, that obviously intentional to meet that requirement and also just give the house a low profile look into the existing site. We were also aware through High Cliffs, through the Architectural Review Board, that the neighbors to the west were concerned about how that would impact their view from their lot. Their lot is still vacant. It looks like they bought it this past December, about the time we started on this project. But we wanted to be cognizant about the neighbors and how it would look from their lot. So from their view, it will be a very low profile of the rear of the garage looking from their lot. And in addition to that, we've been working with the ARB to provide, maintain the existing trees on that side for one thing as a landscape buffer, but also to add additional plant material including evergreen trees and shrubs and so forth, based on those discussions. The other thing I'll mention about the overall kind of layout is there's an existing road cut that we're using for the driveway entry. So with that, that was, also intentional to limit the amount of grading and disturbance that we'd have on the lot. In accordance with the protected ridge guidelines, we're allowed to have 15% disturbance on the lot. And since the lot is 5 acres, and this is actually a relatively modest house compared to what many of the previous projects I've worked on with Livingstone. So with that allowable disturbance of 15%, we're actually proposing only 6% disturbance through the site planning kind of components that I mentioned. The impervious areas, the allowable and the protected ridge is 8% of the lot, and we're coming out at just over 3%. So we're well within those requirements. For the house height, the average house height is permitted to be 25 feet, and with the things I mentioned about embedding the house into the hillside intentionally and working with the architect, we're at about 22.5 feet for the average height. So we're well within all those standards. As I mentioned, I would consider this a relatively modest house. The footprint is only 2,800 square feet approximately. So as Justin mentioned, the one particular standard we're looking for leniency on is the lot, the house width as it relates to the lot. So 30% of the lot width. And so yeah, as Justin mentioned, the lot from north to south is approximately a third of a mile. It's 1,700 feet, but it's narrow at only 200 feet approximately in the best case scenario. And it appears to be the narrowest on this particular street. And yeah, as Justin alluded to as well, the neighbor to the east had previously owned this particular lot, and they ran into the same issue where they were into design. They weren't meeting the particular requirement for the house width, and their solution was that they bumped out into our client's lot. They adjusted the property boundary, and that basically passed the buck to this particular project, and created it, made it even more narrow and difficult to meet this requirement. The last thing is through our coordination with the planner, they were measuring, well, the zoning code, the protected ridge standard, as was mentioned in the introduction, is for the downhill faces of the house. So we were measuring here at the main body of the house because this sits on a knoll. So this downhill face, and we also know we're aware we need to comply with the east face as well because that face is downhill. So that east face is well within compliance. There's no problem with that one. It's this side. It was a surprise to us that the planner is measuring all the way from this corner. Can you see my cursor, by the way? They're measuring all the way from this corner of at the front of the garage and all the way to the farthest face of the house. But then that's basically being, this is the downhill face. So that's where the discrepancy was and how they were interpreting that versus how we were seeing that. So as I see it, the variance request is twofold. One is to request that the width of the house, where they're measuring the width of the house, becomes the same plane that we measure the lot width. Because the diagram they sent, they were measuring the house width in this worst-case scenario at the front, but they appear to be measuring the lot width at the back where it gets narrower. So the first part of the request would be to, I believe, measure along that same line so that we have a little more lot width to work with. And the second part of that, it then becomes the calculation, if my math is correct, is basically requesting just a 7% increase over the standard. So those numbers in particular would be measuring where they're measuring the house width. It would be approximately 223 feet from between the lot lines. And that would, in terms of the house width at that location being 105 feet, that would mean we're requesting the house width to be 47% of the lot width. So I'm sorry, I said a 7% increase. I should have said 17%. So that's what's being requested as part of this variance.
Any questions? One second. Mark? Gabe? Gabe? Greg? No? There are no questions, but Joel?
Yeah, you're providing testimony as the builder?
I'm providing testimony as an expert witness, as the landscape architect of record on the project.
Okay. Let me ask you this. Are you required to be licensed in this?
Joel, I did not hear you request expert status.
Oh, I'm terribly sorry. And I'm not sure of all the lingo. I assume that would be my role. I'm the landscape architect of record on the project. I'm licensed in the state of North Carolina. So the plans that go in have my professional seal on them for the site planning and these components of the project.
Amy, should we consider his credentials and determine and label him as an expert witness?
That's for you to decide, but you can decide based on the testimony that he's given to accept his evidence as that of an expert.
I think he demonstrated as a licensed landscape architect that we can tender him as an expert witness.
A second? Any vote yea? Nay? Right. Now you can ask him as an expert.
Okay, looking at the site plan here, so the main issue is the garage.
That's the main issue, correct?
Okay.
Yes.
So I see it allows for 3 spaces. What would be the feasibility of changing the design? I see kind of the corridor there, which is AC units, but lining that up with the structure of the residence, would that help meet the standards, and is there anything preventing you from doing that? Because I see you have quite a large auto court there.
Right. There's certain templates that are used to assure enough backing distance from the garage to turn around. So the auto court was based on some standard templates from the time saver standards of landscape architecture. So that's how that was sized. But yeah, to your question about the garage itself and the layout of the house, the connector between the house and the garage is basically the foyer and the entry. And the architect did, we've gone kind of around with a lot of internal meetings for the past few months when this first came up to see if there was an alternate floor plan, and trying to align the garage with the house eliminates a lot of the things that the owners liked about the original plan. And it changes the floor plan significantly, and it's not nearly as desirable of a layout to them trying to do that.
So basically, it'd be more desirable to have the garage totally separated from the residence.
That would be a possibility, and we actually asked that question of the planner, and you know, that was one of the first things we asked, actually, was if the garage were detached from the house, then could we measure just the house at that point to conform with the standard? And the answer we got was that the detached garage would still count in the measurements. The owner was willing to make that move and have more of a breezeway between the garage and the house, but it didn't seem to be acceptable by the planner that was reviewing this.
Okay, the other thing is well, the first person testified mentioned other homes in the area and their relationship to the overlay.
Yeah.
Okay. Having been mentioned, do you have any maps, locations, or whatever that the board could see that?
If we're able, we could pull up the GIS information.
In the file.
Joel, did you look at the maps that are in the file?
Of other homes?
No.
I'm looking at the overall map, but it doesn't show anything.
The map section actually shows.
The map section shows the neighborhood and the four neighboring houses.
No, I don't see any other residents. Not even the map exhibit
So
or maps.
this view shows the overall parcel in blue. So this is where I was talking about if you, sorry, I'll get in the microphone here. If you're measuring from approximately here at Cliff Ledge Trail all the way down to, it's all, you know, the grade is falling toward the northeast here. And if you measure all the way to the rear property line, that's what I was mentioning, that's about 1/3 of a mile, actually. You can see how narrow it is in relation to the surrounding lots. This is the neighbor I was mentioning or here rather. This is the neighbor that owned both lots initially, ran into the same difficulty with this particular width standard. And you could see this triangle piece approximately where my cursor is. They adjusted the lot line so that they could meet the width requirement for their house that they're currently building here where my cursor is. And so it narrowed this down further, and then they sold the lot to the current property owner, Cogdill. And so the house, in relation to the site plan and everything, is where my cursor is shown here approximately. And we're trying to, you know, conform with this narrow width in here to meet this particular standard for, again, what I would consider a modest house on a 5-acre lot. And you could see the adjacent parcels to the west, for example, if you were to take the house that is currently proposed and move it to any of these adjacent lots, it would fit without requiring a variance on this.
And that was one of the questions I'd asked, whether it got moved. So
Yes, sir.
you're confident that this particular design would fit elsewhere on these other adjacent lots?
I believe it would. We did that study for, as Justin mentioned, for the adjacent lot to the west.
Okay.
Visually, I'd be confident in saying that it likely fits on the farther lots away as well.
I do have a question. To be clear on the variance, are we just, are we giving it an approval based on just approval that the measurement difference between the staff And are you asking for the staff's rules to be changed or varianced, or just the overall calculation be varianced? Because it sounded like you were asking both.
Well, we were, it was a little confusing the way it was being measured in a diagram that was sent by staff. I don't know if that diagram was submitted to the record or not. But it was basically, it was not an apples to apples comparison. And I'm not sure quite how to get back to the site plan. There we go. So, yeah, and again, do you happen, is that diagram by chance
have it.
in the record?
We have it. Can staff clarify that question, though? Who's the staff on this one?
Could you just repeat the question?
Yeah, I'm just trying to clarify what we're saying a variance is yes to, right? Is it just on the overall percentage? Are we trying to say that doing different math than you did to get the same calculation, or we're saying we approve the percentage difference?
My understanding is that the variance would be to approve the site plan that has been presented to you with
Okay.
respect to the building width and its relationship to the lot width.
Okay, we're just approving that. Okay.
As opposed to getting into the details of the numbers and the percentage. Yeah, that's why I was writing the numbers and percentage down as well, so. at the
That
end-
would, yeah, in my opinion, that would be the most ideal scenario. You know, I was just thinking ahead that if, you know, to look at it in terms of how it was being measured in the staff diagram versus, you know, how we're measuring it. So the staff were measuring it from this corner all the way to here. You know, kind of the worst case scenario for the house and the garage together. But they seem to be measuring the lot width back here at the downhill slope. So the protected ridge guidelines speak to it being the faces of the house at the downhill slope. So the lot is narrower there is what I was indicating. So it makes it even harder to meet that standard and requires more of a larger variance, if you will, than
Right.
if they were measured along the same plane.
We have a time check. We're at 4:04, 4:05. We're 5 minutes past our volunteer time. And so I'm going to ask, are there any critical questions that you need to have asked of this witness at this time? That's what I'm trying to close to, Joel. So you have no questions to this witness?
No, I've got some comments.
Okay. Mark, you have any questions?
Just one quick question. So it's your testimony that this design is the only one that'll fit on this lot? There's no modifications that can be made to find something more suitable that conforms to the lot width?
We spent a number of months, the past couple of months, going back and forth about that. We tried every configuration we can think of about rotating the house or moving it up and down, moving it side to side. This was the best fit, in my opinion. All the other kind of site planning options had other negative consequences, either being more disturbed area, more trees to be removed, more impervious area. The house height starting to become a challenge when moved. And then the septic system has been analyzed and is suitable for the one particular area shown. So we also have that as a constraint.
All right. So in order to pass a variance, we're going to need all 7 people to vote on this, correct? And a unanimous decision? And Joel is about to leave.
Oh, 6 out of 7.
4/5?
Supermajority.
Okay. So Joel, if you need to leave, you can leave and we can vote, but I'd rather have you stay for the last few minutes here.
How much longer?
Any other questions for this witness?
I've got one, real quick. You mentioned the lot line change from the previous owner. So if that lot line were not changed by the previous, because in my estimation, that lot line adjustment may or may not create this hardship. If that was the case, would you still be before us for a variance?
I don't have that particular information on hand.
Okay, that's kind of where your presentation was going, that they kind of basically shoved this off into your laps by making that lot line. That's what I heard in your testimony. So
Yeah, I'd like to speak to that, but I don't have the exact numbers. That was done as part of a lot line adjustment, and we just saw a document online that indicated that that was done, and then figured out why it was.
My question is, once you discovered that you and the staff were measuring this differently, have there been any changes made to the plan since the discovery of, okay, we're measuring differently and that's the problem? In other words, with the discovery, were any changes made, or is this the same plan that was presented to them where they discovered the problem?
We went through extensive meetings back and forth and studied a whole number of different options, and then realized that this is still the plan that fits the best for, as far as we're, in my opinion, for the site plan. And we coordinated with the architect, as I said, and they were trying a number of things to see if it could be solved via the floor plans, but they were much less desirable. They impacted a lot of the things that the owners liked about the floor plan that was designed. So we currently have the same plan.
So there was no changes?
That's correct.
Okay.
Yes, sir.
Any other questions? Do you feel you've made your case?
I believe so, yes, unless there's anything else I can clarify.
Hearing no other questions, do you feel like you're ready for deliberation, or any other questions? All right, so we're going to close it to, thank you very much for your presentation.
Thank you for
very
your
much
time.
For your testimony. Now let's close it from the public. What is our conversation amongst board members? How do you guys feel?
I've got a few things.
Okay, share.
I guess I would just say, I mean, I understand everybody, trying to make an argument. I've spent a lot trying to do the same thing. I think to, say that this house with, a monster 3-car attached garage and, a courtyard, and to say that it's a modest home, I mean, I don't know what neighborhood these guys are living in, but this is, and I mean, God bless them. I want them, everybody to have all we can, and I think as a board, we're here to help, when we can. But, this is an exceptional thing. And like I said, I don't know that I'm opposed to it, but I'm not also sure that it fills the bill. I mean, by the strict code of what we're supposed to consider, I don't know that I'm feeling it. And I might want to ask the staff again to briefly give us those bullet points. So that's my thoughts.
So while staff gives us the bullet points for granting a variance, question Gabe, so your comments are going to, the house design is within the scope of your realm of adjustment as opposed to the overlay limitations of the lot.
Yes. And I'd like to hear the rest of the board's thoughts. I mean, I don't.
I mean, one of the challenges is obviously septic, right? So if you've got a septic challenge, you've got a narrow lot already with septic challenge. And it sounds like, you got topography, you got septic, and you got, because topography plays into the height piece, right? And so, I think there's 3 variables to this, and I think this seems to be the variable that, given some different measurement stuff or the way it would have come, it would have been different. But I think they did bury the garage into the hillside, so it's not, I think that's part of what I'm thinking about, is that we're not dealing with a sugar mountain, which is really where this whole thing was created, about the ridgetop protection, right?
So it's been a minute.
I feel like they've tried to put this into, in the essence, I guess, of what we're trying to say is the steep slope variance. Or we're really saying, does this fit in with what the steep slope was intending to? I think with trying to bury the garage, even though it is 3-car, whatever, but burying it into the mountainside, trying to take into account the topography and some of the trees that are there. I mean, there's some decent trees that will be on the backside that'll be protected in this. Those are some of my thoughts. There's some measures that have been made. It's just not.
Okay. I think those are good,
Yeah, and
good
that's-
points, and I appreciate you pointing them out.
Yeah, and this development ordinance is very hard to, it's on purpose made that way. And I think they have demonstrated some efforts to go beyond and other points of that requirement, that impervious wise, other things that they don't have to, so.
And just to confirm for us again, there is nobody withstanding.
That's correct.
Okay.
There's nobody withstanding.
Okay.
Do you want to hear the requirements? now, or are you comfortable with?
Go ahead.
Yeah.
Let's-
Griffin, can you rattle through what are our thoughts according to the?
This is just reciting the
Yep.
requirements
Yes.
for
Yep.
granting a
The
variance.
requirements.
When unnecessary hardships would result from carrying out the strict letter of the zoning ordinance, the Board of Adjustment shall vary any of the provisions of the zoning ordinance upon a showing of all the following. A, unnecessary hardship would result from the strict application of the ordinance. Shall not be necessary to demonstrate that, in the absence of the variance, no reasonable use can be made of the property. B, the hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for granting a variance. C, the hardship did not result from actions taken by the applicant or the property owner. The act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance shall not be regarded as a self-created hardship. D, the requested variance is consistent with the spirit, purpose, and intent of the ordinance such that public safety is secured and substantial justice is achieved.
Thank you. Thank you.
So, Chair?
Any other thoughts?
Yeah, just one small thing. I'm looking at the applicant's answers to the questions that were just talked about, and in an answer to the first question, they say strict enforcement of this standard would result in a house redesign that would disturb more area and increase the house height, which is limited in the protected ridge overlay. This change would be counterintuitive to limiting the intensity of development along the protected ridge, which sounds like a good argument to me in favor of granting the variance.
All right, any final comments?
Yeah.
Before, Joel, you're the one that I'm trying to rush this through. You got a question?
Well, I've got a comment. These proceedings gotta be fair.
Okay, then continue to join us and share with your
Yeah,
thoughts.
just quick, two concerns. From what I heard of the applicant, the structure, right now, there's a breezeway between the residence and the garage. And it looked like a pretty large auto court. And from what I heard of the applicant, without the breezeway, the residence wouldn't be desirable, okay? So that's almost to me like he's creating his own hardship. The other issue I have too was the statements about other properties, but nothing was presented, which especially at least one property said some modifications had to be made, I guess, to fit the zoning regulations. So I have a hard time supporting this because said there was other numerous designs, but we don't know the details or whatever. And if you have to go without a breezeway, you go without a breezeway.
I have some comments too. When I look at the standards, specifically the unnecessary hardship, when questioned about modifications to the houses, the answer was it would become less desirable. To me, that doesn't meet the bar for an unnecessary hardship that results in a strict application of the variance.
Right. Anyone else want to share their thoughts?
I mean, I guess I go back to you, well, you're talking about the neighbors and stuff. That's not one of the things that we're really supposed to consider as the neighbors. That's not something we're not supposed to consider. It's not really what we're focused on here. And I think to your point, it's like, what do we look at? I think the intent here is not necessarily the hardship of breezeway or no breezeway. I think it's are they trying to get it fit into the mountain and keep with the overarching, the elevation, or what do they call it, steep slope ordinance, really, limiting the building being sticking out, right? Like breezeway or not, I think they're trying to maximize by putting it in the hillside and keeping it tighter in and keeping the trees to keep it from sticking out, which I think is the goal of it, right? Trying to meet the essence of it more is what I would say.
And the percentage of disturbance on the property.
Correct.
There are
And
a
the
number
height
of
disturbance,
things that
yeah.
are limiting what they can do, and it isn't just simply if you get rid of the breezeway, that'll solve it.
Correct.
I don't know that, if you want to go in and do a 1,200 square foot home with a one-car garage, I'm sure it would fit. But again, I don't know that in my time sitting on the board that we've put such a burden on people who've come in asking for a variance. We have taken what they've desired and said, okay. And we have the authority to say what harm is this going to do and how is this counter to the intention of the ordinance.
And I think there was an intent to comply. I think there's a nuance of how this, is this ordinance is enforced that may or may not have been planned for. So I agree. I think they've done a lot of hard work to make this thing fit, but they're just in a spot where this particular plan, we're in this spot. So it's a tough one. I think in the intent, I think they did everything to meet the intent of the steep slope ordinance restrictions. And this lot, just terrain, geometry, septic, all these, are just got this one spot that's causing a problem.
One more, just quick sentence. Our job isn't to enforce the ordinance, right? If our job were to enforce the ordinance, we'd never grant a variance.
Correct.
Correct.
We're provided guidance, and it's our job to take that guidance, but then to render a decision.
Yep.
And we have the authority to do so with a 4/5.
Of all board members, so if Joel had to leave, it would then turn into a unanimous.
It would, yeah, that's right. Okay. Any other comments? Anyone bring forth want to pull one of those sheets and make a decision on whether it's a green one or a red one? And the moment has come. Gabe, you got it?
All right.
Gabe's got it.
Mr. Chair.
Yes.
Based upon the evidence presented to this board, including the following exhibits, the petitioner's application, submitted development plan, the GIS maps, the staff report, testimony presented at the hearing, I move the board adopt the following findings of fact. This matter was properly advertised, is within the board's jurisdiction, and right for its consideration. That this application, together with conditions proposed by staff and/or this board and agreed to by the applicant, does meet the requirements for granting a variance contained in the Buncombe County Code of Ordinances, Section 78-621, Paragraph 3.
Have a motion to approve. Is there a second? All in favor of approval? Aye.
Aye.
Anyone opposed? All right.
Mr. Chair, based upon the foregoing findings of fact and for the reasons set forth therein, I move that the requested variance be approved and that the order approving the permit be adopted and executed as presented and as modified in this meeting.
We have a motion. Is there a second?
Second.
All in favor? Aye.
Aye.
Those opposed? One opposed? 6 approved. It passes. Now we have an order.
Yeah, it's much shorter than the previous ones.
Thank you, Amy.
This matter was properly noticed and advertised. This board has jurisdiction. All notices were sent, proper signage was posted at the property, and sufficient legal advertisements were published. The applicant applied for a variance to the zoning ordinance to request an increase in building width for a single-family residential dwelling. The property is located in an open-use district. At the hearing, the applicant and any parties withstanding were given the opportunity to offer evidence. With respect to an unnecessary hardship would result from the strict application of the zoning ordinance. The hardship does not result from conditions that are peculiar, the hardship does result from conditions that are peculiar to the property. The hardship did not result from actions taken by the applicant. The requested variance is consistent with the spirit, purpose, and intent of the ordinance. And the application taken together with any conditions referenced above, and there weren't any, satisfies the requirements for granting the variance. And now therefore, the variance is granted.
We have an order. Do we have a motion?
Move to approve the order.
All in favor, say aye.
Aye.
Those opposed? Thank you.
Motion to adjourn.
Motion to adjourn. Approval. Congratulations.